Item number 1 for delivery forward.
For reasons mentioned in the order, the interlocutory application is hereby dismissed. And the main revision petition shall be listed as per the last order after 4 weeks.
Details.
May I please optimize? My lord, a matter has been filed on 28/3/2024, my lord. It is behind the bar for 47 days, my lord. Mandatory is 60 days, my lord. There's some urgency, my lord. Can it be tomorrow, my lord, not today, tomorrow?
Matter pertains to
Matter pertains to my
less than
lord.
7 years.
Some, my lord, black paper has been.
Offense less than 7 years.
Yes,
May it please the lordship, my lord, very unusual circumstance, my lord, I'm making a mention. Generally, I do not disturb the board of the courts, my lord. A person was arrested under the Money Lending Act, which is bailable. But unfortunately, some illegal act of the police, my lord, he was arrested and actually this is a police atrocity. And lower judiciary also, my lord, did not allow the bail. So he's behind the bars, my lord. Can it be taken up today, if not, my lord, otherwise
No,
inconvenient?
not unlisted. It has to come as
Yes, yes.
due course.
Tomorrow, my lord.
Otherwise, all will pray for this.
My lord, I'll ask tomorrow, my lord.
Have you filed?
Yes, yes, today morning, file.
Let it come as per normal course.
No, my lord, kindly tomorrow, my lord. It's a absolute, I'll show to your lordship, absolute
What is the
illegal.
offense?
My lord, money lending is, this is bailable offense.
No. How much is the punishment?
It's
Less
below
than-
7 years, a fine only, not even punishment.
Okay. Tomorrow.
Tomorrow, oblige.
May I please?
I beg to mention, my lord, item number 10. Item number 10, my lord.
Yes.
I seek adjournment, my lord, for 2 weeks, my lord. I need some instructions.
Heard Mr. A.R. Talukdar. Have you informed the other side?
My lord, other side is there. my lord.
Respondent,
I'll inform them, my lord. I sought them, but I did not find here. I'll inform them.
heard Mr. A.R. Talukdar, learned counsel for the petitioner, who prays for an adjournment on the ground that he has to seek some instructions from the petitioner. He has also submitted that he would inform the learned counsel for the private respondent. Stop. Learned additional public prosecutor does not have any objection to the prayer made, hence the prayer is allowed. Let this matter be listed after 2 weeks.
May I
Publish.
please, your lordship?
Publish.
Your lordship, I beg to mention item number 25. CD has not come today. 25. Sorry, 25. Maybe fix after any date. Date may be fixed. Your lordship.
Heard Mr.
S. Sakya.
S. Sakya. Also heard Mr. B. Sharma,
My lord.
who submits that the case diary has not arrived
My lord.
and prays for some another date
My lord.
for producing the case diary. The prayer is allowed.
20.
Let this matter be listed after 2 weeks. Fix it.
My lord. Lakhimpur, my lord. Kindly date may be fixed. My lord.
On
After,
20
my lord. 25th, my lord.
25th April.
Much of it.
let me, your lordship. Lordship, item number 36, lordship, today's list, lordship. And the adjourn for the day, lordship, and after Bihu can it be, lordship?
Item number?
36. Personal difficulties to the lordship. I'll leave the court.
Are you in? Do you have interim order?
Lordship interim is there. But lordship, hardly I have leave this court. I have some personal.
It is available, my lord.
CD is available.
After you any date, lordship, only for convenience of the court.
It has to be before Bihu.
It was before, lordship.
Heard Mr. F. Hawk, learned counsel for the petitioner, who prays for an adjournment on the ground of personal difficulty. Considering the submissions, the prayer is allowed. Learned additional public prosecutor has submitted that the case diary is available.
My lord.
Same may be retained till the next date. Let this case be listed again on 9th of
9th.
April.
Lordship. Lordship, another prayer, lordship, and criminal petition, lordship, and can it be on 5, lordship, for listing? Criminal petition.
No, criminal petition, there are other senior courts. You have to mention-
Published.
May it please your lordship, I beg to mention for listing a bail application for motion for tomorrow. Lordship. Urgency is there. I filed Saturday lordship.
What is the offense?
420 is there, lordship.
Right.
420 is not applicable at
Right.
all in this. Tomorrow.
Oblige your lordship.
May I please, your lordship, beg to mention for listing of an IA lordship in a pending criminal appeal lordship. Filed it for bail lordship. On the last two occasions.
No, you have to mention it before senior court.
Senior.
Lordship, but equivalent to 7 years it was given here, your lordship.
No, but it pertains not, it pertains to a pending appeal, criminal appeal.
Yes, your lordship, but
There are other senior courts taking a roster of criminal appeals. So you have to mention before the senior most court.
sorry, your lordship. Oblige.
So I get to mention two bail petition for listing lordship. Day after tomorrow, it is for hearing lordship.
What
And
is,
this NDPS matter. lordship.
okay.
May I please your lordship? Lordship, I beg to mention item number 29, lordship.
Mr. Majumdar, NDPS also, there are senior courts. Court number 14 you have to mention.
Lordship,
Justice. There are other,
I
Court-
believe 18, lordship. Court number
court number 18.
18.
Special acts. Your matter pertains to NDPS.
NDPS.
So special act, court number 18 is also taking. it. So 18,
May I please your lordship? Lordship, I beg to mention item number 29, lordship. We are behind the bars, lordship. The case diary has not been received. Lordship. Kindly let the matter be fixed on third, lordship. It's already behind and today. The date was fixed for case diary, lordship.
My lord, matter may be fixed on Friday, my lord. Here I will also send a notice, report that my lord, praying for another date, my lord, for producing the case. Let's make fixed on Friday.
item number 29,
29, lordship.
Friday, my lord.
heard Mr. V. A. Chaudhary,
Lordship.
learned counsel for the petitioner,
Okay.
also heard Mr. B. Sharma, learned additional public prosecutor, who prays for another date for producing the case diary.
Let it be on fourth, lordship, Thursday.
My lord,
We're already behind, lordship. It's a public servant.
I pay for Friday, my lord.
Fridays,
Fifth, my lord.
Thursday, can it be one day early? Today it was fixed, lordship.
no, but we have to receive the case diary.
Lordship.
On request of learned additional public prosecutor, let this matter be listed again on 5th of April.
Fifth. Highly object.
My please, your lordship.
Mhm.
My lord, I'm praying for listing of a anticipatory bail application, my lord. Tomorrow, my lord.
Item number?
No,
Matter pertains to,
matter pertains to my lord, IPC, my lord, sections.
what is the punishment?
Punishment is more than 10 years. my lord.
More than
Then senior court,
my lord.
Senior group, policy,
18.
Oh my.
May I please your lordship, can we allow for filing a listing of a matter regards to family court trial criminal revision petition? Can it be mentioned for your lordship's court? Family court trial matter, your lordship, criminal revision petition against an order. The next date is given on 9th of April. Criminal revision petition.
Court number 12,
Much obliged.
May I please, your lordship? Lordship, 439 application, my lord. My lord, case number 14, FIR, a vernacular person.
376. Case diary would be.
My lord. It is also my lord.
My lord, may I read out my lord?
Foxo 4 is also there, my lord.
POXO is also there.
My lord.
Foxo there, but my lord, please peruse the FIR, my lord. May I please, your lord?
No, where is the rejection order?
Rejection of the case number 16, my lord.
18-month-old baby, lordship. He is suffering from lordship.
Case diary. would be-
Kindly on this Friday, lordship, the case diary, lordship. He's from Horulumuk, lordship. No recovery plus 18-month-old baby, lordship.
Heard Mr. S. Munir, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. Perusal of
Immediately.
case diary would be necessary. Hence, call for the case diary. 16. Fifth of April for case diary.
Lordship on Friday, Lordship. This
আছে আছে
Friday is fifth.
Lordship, much obliged. Much obliged. Much obliged.
Item 4.
May I please, Lordship? My lord, section 4 of POCSO Act is there, my lord. So, my lord, at this stage, my lord, case diary, call for the case diary, my lord, and my lord, notice should go, my lord.
item
4, my lord. It is from
Mr.
Happy.
SH.
POCSO form is there ma'am.
Signet. Perusal of the case diary will be necessary, hence call for the case diary. And issue notice to the respondent number 2 as per the mode prescribed by the division bench of this court in the case of Deepak Naik versus State of Assam. The petitioner shall take steps,
Throw officer in charge, my lord.
service of notice on the respondent. Yes,
May I read, my lord? With due respect, beg to state that the below mentioned scheduled land had been purchased by deed number so and so dated 25/2/93, but Monima Sarkar has presently prepared a power of attorney on 19/11/2019 by showing another woman in my place. Anonymous Sarkar has sold my land to other person. This is the, my lord, main allegations that one Onima Sarkar had, my lord, fraudulently executed one power of attorney and sold the land of the informant. My lord, the Lordship, my lord, I have annexed this sale deed, my lord, that Onima Sarkar has sold land to my client, my lord. Lordship will find page 17 is the registered sale deed, my lord. 17, my lord.
no, what is the allegation?
The
Anima
allegations is,
Sarkar
my
has
that
fraudulently.
one Onima Sarkar had, my lord, fraudulently prepared one power of attorney and executed, my lord, sold the land of the informant, my lord.
Okay,
Now, this is the allegation.
now that land has been sold to you.
No, my lord. I am the identifier, my lord, being an advocate, my lord,
Okay,
and sold to my client, my lord, and that Onima Sarkar has sold her own property, my lord.
no, your client is an advocate, you said.
No, no, my. The petitioner before your lordship is an advocate. Petitioner, my lord, is
Okay,
an advocate, my lord.
and who is your client?
Client, my lord, they are the, my lord, farm, my lord, registered farm, my lord. They have purchased the land from the Onima Sarkar, and that land, my lord, she is the owner and recorded pattakar, my lord. That's registered sale deed after due permission from the, my lord, deputy commissioner as well as, my lord, GMDA, my lord. That sale deed has been executed, and I am only the identifier. That lordship will find page 16, 16. Lordship got in, my lord. In the right hand, my lord, below, my lord. Page 16, this sale deed part, my lord. Right hand side, below, my lord, I am the identifier.
Whom you identified?
My lord, my lord, my lord, the purchasers, my lord.
Purchaser.
Yes, my lord. That page 17, lordship will find. This is the registered sale deed, my lord. And
Why are you apprehending arrest?
my lord, because, my lord, the police has, my lord, talked to it over phone, my lord, and asked me to appear, my lord. This is the, my lord. In fact, my lord, the my client, that is the purchaser, has already approached this honorable court, my lord, and this honorable court, my lord, passed and, my lord, interim order, my lord. This is the order, my lord.
Heard. Mr. R. Sharma, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. This and this application under section 438 of the Code of Criminal Procedure, 1973, has been filed by the petitioner Rubul Das, who is apprehending his arrest in connection with Bhangagarh Police Station case number 26/2024 under section 120B/420/406/468 of the Indian Penal Code, corresponding to GR case number 1392/2024. The gist of accusation in this case is that on 29/1/2024, one Shri Vishnu Priya Hajorika had lodged an FIR before the officer in charge of Bhangagar Police Station, inter alia, alleging that one Anima Sarkar had fraudulently prepared one power of attorney on 19/11/2019 and has sold the land of the first informant. Stop. Learned counsel for the petitioner has submitted that the petitioner is an advocate by profession and he has only identified the purchaser to whom the land was sold by the named accused, namely Anima Sarkar, by executing a registered sale deed. It is submitted by learned counsel for the petitioner that apart from the identifying the purchaser, he has no role in this case. However, the police is searching for him, for which he is apprehending his arrest in connection with this case. Learned counsel for the petitioner has also submitted that in the meanwhile, the purchaser, that is the client of the present petitioner, who has been identified by the present petitioner, has already been granted interim bail by a coordinate bench of this court in AB case number 805/2024 by order dated 28/3/2024. Stop. Perusal of the case diary would be necessary, hence call for the case diary. When
Same date.
That is fixed on 22.
let this case be listed again on
4.
22/4/2023. However, in the meanwhile, as the purchaser who has been identified by the present petitioner has already been granted interim protection by the coordinate bench of this court, as well as the allegation in the FIR is mainly against one Anima Sarkar and not against the present petitioner. The present petitioner is directed to appear before the investigating officer of Bhangagar PS case number 26/2024 within a period of 10 days from the date of this order and cooperate in investigation. Stop. If he does so, within the stipulated period of time, in the event of his arrest in connection with Bhangagar PS case number 26/2024, the above named petitioner shall be allowed to go on interim bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of the arresting authority with following conditions. Condition number 1, let this case be listed again on 22/4/2024.
Item 6. Along with my lord, they are. Along
No,
with.
that registry will do.
May it please your lord. This is 438 application, my lord. FIR at page 14, my lord. Basically, my lord, it is allegation is that, my lord, that non-clearance of dues, my lord. In the FIR itself, it is written, my lord, that and allegation is against Isikesh Chaudhary, my lord. Main allegation, my lord. Not against me, my lord. Page 14 is the FIR.
What is the allegation?
My allegation, my lord. May I read the FIR, my lord?
Yes.
Madam, with due respect, the undersigned would like to inform you that I am the proprietor of surgical house situated at MG Road, Bongaigaon, and as such, I am dealing with surgical products of various companies since long. That Sri Isikesh Roy is employee of JB Chemicals and Pharmaceuticals Limited, having Bongaigaon headquarters, and the company is doing regular business with me through his above named person. And apart from his service, Rishikesh Roy also doing partnership business with Kamal Mandal, the proprietor of Ma Kali Drugs Agency of Polpara, Bongaigaon. That, sir, the above named Rishikesh Roy induced and abates me for doing business with Kamal Mandal, the proprietor of Ma Kali Drugs Agency, Polpara, Bongaigaon. On his false inducement, I had supplied various products of JB Chemicals and Pharmaceuticals Limited, along with the products of other companies to Ma Kali Drug Agency, amounting to rupees so and so, with 11 lakhs so and so and so and so and so. 7 as per last account statement dated 12/1/24, and since then I have been repeatedly requested Mrs. Rishikesh Roy and Kamal Mandal to clear my dues, my lord, but they avoid me to return the aforesaid bill amount. So basically, well, it's a non-clearance of dues, my lord. They would ought to have filed a money.
Who are you?
I'm Kamal, my lord, Kamal Mandal. And Kamal Mandal, and main allegation is against Rishikesh Chaudhary, my lord. And my allegation is that we have
No, against you also, you have not cleared the dues.
dues, my lord. He ought to have filed the money suit, my lord.
Okay, this is basically. Now, what is your submission?
But that is my submission. And main allegation is against Rishikesh Chaudhary, my lord. Rishikesh Chaudhary, my lord, he is doing the business, my lord. And my lord, it's a, they ought to have filed the money suit, my lord, for clearance of dues, my lord. Section 420 may not be attracted here, my lord.
Heard Mr. S.M. Abdullah P, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. This application under section 438 of the Code of Criminal Procedure, 1973, has been filed by the petitioner Kamal Mandal, who is apprehending his arrest in connection with Bongaigaon PS case number 93/2024 under section 109/420/34 of the Indian Penal Code. The gist of accusation in this case is that on 4th March 2024, one Shri Sujit Datta had lodged an FIR before the officer in charge of, North Bongaigaon Police Patrol Post under which police station?
Bongaigaon Police.
Under Bongaigaon Police Station, inter alia, alleging that the first informant has supplied various products of JB Chemicals and Pharmaceuticals Limited to the present petitioner and one Rishikesh Chaudhary. However, they have not cleared the outstanding dues and thereby cheated the informant for their wrongful gain. Stop. Learned counsel for the petitioner has submitted that the dispute between the informant. Learned counsel for the petitioner has submitted that the main allegation in the FIR is against one Mr. Rishikesh Chaudhary. It is also submitted by learned counsel that the dispute raised in the FIR is predominantly civil in nature, and the petitioner is ready to cooperate in the investigation. However, as police is searching him, he is apprehending his arrest in connection with this case. CD would be required.
Civil case.
Mr. Sharma,
My lord, at this stage, lordship may call for CD, my lord, to find out his involvement, my lord.
when CD,
My lord, CD, my lord,
Number
24, my lord.
perusal of the case diary would be necessary, hence call for the case diary fixing 24 April 2024 for the case diary. However, as from the bare perusal of the FIR, it appears that the allegation made against the present petitioner appears to be civil in nature. The petitioner Kamal Mandal is directed to appear before the officer in charge, before the investigating officer of Bongaigaon PS case number 93/24 within a period of 10 days from the date of this order and cooperate in investigation. Stop. If he does so within the stipulated period of time, in the event of his arrest in connection with Bongaigaon PS case number 93/2024, the above named petitioner shall be allowed to go on bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of the arresting authority with following conditions. Number 1 and 2. Fixing 24 for
Oblige money.
Item 7.
Yeah, question. And in this case, my lord, I was. So. I was implicated based on the interrogational statement of the arrested,
based on
interrogational statement of the arrested person. Nothing was recovered from me, my lord. I am
number?
8, 6, 7.
this is a case under.
This is a case under section 21C, 25, 29 of NDPS.
Okay.
And my
Case
lord,
diary would be.
My lord.
Investigation is going on.
Going on.
charge sheet is submitted, and then I was shown as an absconder, and subsequently, my lord, NBW was issued, my lord. So page 39, my lord. Page 39.
Now, what is
the-
your case?
I'm sorry.
You are paying for bail.
Bail, my lord. Now, similar order passed in page 44, my lord. Page 44. Similar case, my lord. Honorable Court, my lord,
What
It's a-
similar order?
similar to page 44, my lord. In this case also, the under section 438 bail was
And
granted.
it was granted after going to the scan copy, my lord.
My lord, kindly see,
Here not so call for yet, my lord. Scan copy.
kindly see page 46, my lord.
Yes.
Page 46, my lord.
Para
It
6.
is para 7, my lord. It is not a dispute that the case has already been charge sheeted by the IO under section so and so, showing the present applicant along with the two others as absconder, and since the present applicant is willing to participate in the trial and assured to appear before the trial court below, this court is inclined to extend interim protection to the applicant. Accordingly, it is provided in the event of arrest so and so, special individual case number 721 shall be charged on pre-arrest bail on his executing bond rupees of 50,000 only. There are 9, my lord. The above privilege is however subject to the following condition.
That
These
is
are the conditions.
para 6, my lord. Earlier 6, para 6, my lord. He has not read, my lord. Having had the submission so and so, I have carefully gone through the petition as well as documents placed on record and also perused the scan copy, my lord.
My lord, I have
Scan copy
submitted
of
all
the
the
record.
order sheet. Order sheet I have submitted, annex, my lord. Kindly see page
That is
39,
my
my
lord.
lord.
No, this is a case under 21C.
See, my lord.
So you have to first jump 37.
My lord. 37, you will have satisfied, my
So
lord.
for that, we have to peruse the materials.
My lord.
If there are materials against you, you will not even get interim protection. If there is no material against you, only then you will get
My lord.
protection of anticipatory bail.
My lord, here in this case, my lord, it is evident from the charge sheet also that I was, my lord, nothing was recovered from me. I was not present in the place of occurrence, my lord. It is everything in the charge sheet. It is in the FIR also, it is in the charge sheet. May I read, my lord?
No, then why charge sheet was laid against you?
Because the statement was given by the arrested persons,
How you are,
my lord. My lord, kindly see the page 17. During the spot interrogation, the accused Sifaruddin named the other occupants who fled away from the car as Dilwar Hussain and Gulzar Hussain.
I am Gulzar Hussain. So after completion of what, this is the statement
And this is false according to you.
according to me. This is false, my lord.
To
I
find
was
out
not
his,
present in the place
to
of.
find out his involvement, my lord, scan copy is necessary, my lord. Here, it is also said that he's played away, my lord, two of them, my lord, from the statement of the co-accused also, my lord. Other co-occupants who played away from the
Scan
Sir,
copy
the-
of the, at what stage the trial is pending
Trial is my lord.
for appearance?
NBW was issued, my lord, just on 29/1/24. And the.
No, in a case under section 21C, you are seeking protection under 438. So
My
you
lord,
have
my
to
lord.
show that there is no case against you.
My lord, that is,
Your
my lord.
plea is that the statement made by co-accused are false.
False, my lord, not admissible,
We
my
have,
lord.
no, we have to see, is there any other evidence on
My lord.
record against you or not? If there is no other evidence, then you may have a case. For that, perusal of the scan copy of the case diary would be necessary.
Short date may be given.
Heard Mr. H.R. Chaudhary, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. As this case involves contraband of commercial quantity and the offense alleged is under section 21C under of the NDPS Act, 1985. Perusal of the scanned copy of the case diary of Nilam Bazar PS case number 140/2023 would be necessary for consideration of the instant anticipatory bail application. Hence, call for the same. The registry to requisition scanned copy of the aforesaid case diaries. Let this case be listed again on
19th, my lord, just
My lord,
reopening,
kindly
my lord.
Before vacation, kindly before
My
Eid,
lord,
my
it
lord.
will not-
Eid was going to be held on to 11, my lord. So kindly on 7, 8 or 9, my lord.
Today is first, my lord, April.
Petitioner is absconding, my lord.
you are absconding and
Absconding,
you
my-
are seeking relief. under
Relief
four-
from by the
438.
anticipatory bail, my lord.
NBW was issued.
Commercial quantity, my lord.
No, if you are absconding, then you are not entitled to get relief under.
My
438.
lord, my lord.
I am ready to face trial, my lord. So I'm saying. If any,
Then
protection,
face it.
Face this.
any protection, my lord.
Fix it. out.
Reopening, just reopening, my lord, 19th,
11.
my lord.
Kindly, my lord, before my lord. On
11.
8 or 9, my lord. 11 vacation, my lord. Kindly 9th. my lord. 9th. God bless you.
Item 8.
These are 438 application one. These are charge case, already charge sheet has been filed. Here the allegation is that the mother of the victim can lodge the FIR. The allegation that the victim is the 17-year-old and the present petitioner had been maintaining relation with the victim girl for last 2 years. So from the FIR, your lordship will find the FIR page 13, my lord. So ultimately it appears that my lord, there was a consensual relation between the victim and the petitioner. And this FIR was lost, my lord, out of some misunderstanding, my lord, because what I have stated in my petition, from the side of the victim's family,
Who is the informant?
mother,
Mother of the victim girl.
My
mother
lord.
of the victim.
Notice will go, my lord.
Right, with your lordship. 439 application lordship, he is there in custody since 26/8/2022. As on date, 1 year, 7 months, 6 days. And FIR your lordship will find at page 22.
Page 22.
Page 22.
Yes.
Uh,
Allegation is under
Allegation under 20 C lordship, 22C, but if your lordship see
22.
20B2C, 20, 20 lordship.
Ganja.
Yes, Ganja. 20. Here, Lordship, I have two folded submission. First is that on ground of delay, and second, your Lordship will find at page 22 that serial number 1 that is recovered from present petitioner number 1, that is 10 kg. And
Where
that,
serial number 1?
page 22. FIR, Lordship.
Yes.
Serial number 1 and then serial number 4.
You were traveling in the same vehicle.
Same vehicle. Serial number 1 and 4.
Vehicle was a passenger vehicle.
Yes, passenger vehicle. In middle portion, your Lordship will find of the page 22, passenger.
Serial number 1 is?
Serial number 1 is petitioner number 1.
How many petitioners are there?
2 petitioners. And serial number 4 also belongs to petitioner number 1. And then serial number 2 belongs to petitioner number 2. And 5. 2 and 5 belongs to petitioner number 2. 2 and 5. So Lordship, so from petitioner number 1, that your Lordship will find that 10 kg, 10 kg, 20 kg was recovered. And to make a case of commercial quantity, it has to be more than 20 kg.
So up to 20 kg.
Up to 20 kg, it is intermediate one.
Okay. And P2?
And
Petitioner 2?
Petitioner number from petitioner number to 18 kg recovered. 2 and 5, serial number 2 and 5, 10 kg and 8 kg, 18 kg. That is less than 20.
Now why it should not be treated as a that
Because there is absence of abatement and conspiracy. They were traveling in the same bus, they were known, but there was no conspiracy at all. From the FIR as well as from the other evidence on record also. And I am relying on two judgments of court. Of Bombay High Court, Lordship. In Rashida Iqbal Khan, your Lordship will find that she was granted bail considering the contraventions recovered from her possession, Lordship, taking into that.
What is this Supreme Court judgment quoted in cited in?
That is Amar Singh Ramji Bhai Bao.
What it says, Amar Singh?
That for 20 attracting 29 losses, that abatement or conspiracy has to be there.
Okay.
Paragraph 8, Lordship, may I say. Paragraph 8.
8.
8.
Yes. Yes, read.
That just I am missing my copy, Lordship. I'm sorry, Lordship.
Okay. Whether have you taken this plea before the trial court? Earlier.
This plea was not taken.
Trial court rejected your
My bail prayer was rejected.
on the ground that commercial quantity is
Commercial quantity is involved. And apart from that, also I am in
and your submission is that there is no material under section 29. 29, there is no material.
no material also. An individual quantity which was recovered from that has to be taken into consideration also.
Okay.
And second lordship, my prayer is that already they are in custody for 1 year, 7 months, more in custody lordship.
Nine witnesses.
And
For
out
that-
of 9, 4 witnesses were examined. lordship. 3 witnesses were examined. And there is no chance of early conclusion of trial.
Now, if this court observes that this is not a case under commercial quantity in a bail application, would it not affect the trial?
For prima facie lordship, that for consideration of bail prayer. only.
Okay. For prolonged incarceration, what judgment you are
And
relying?
lordship, that for prolonged incarceration.
Yes.
And out of this, your lordship, may kindly say one judgment, that is Omjon Nath case, lordship. That, yes, third one, lordship, that our high court rejected, and thereafter honorable apex court said in paragraph 3, your lordship will find. Taking into consideration the fact that the similarly circumstance accused has already been released on bail by this court, we are inclined to grant bail to the petitioner. Here also, from the High Court order, it appears that there was prayer was made to release him on the ground of that trial was not concluded at an early stage. There was delay in trials, but that was rejected. Against that, they went to Supreme Court and therefore they were granted bail. 1 year, 7 months was there. And in Chitta Biswas case also, your lordship will find that
Yes, what?
Chitta Biswas also lordship that out of 10, 4 witnesses were examined.
But on what ground the bail was granted, it is silent.
That on delayed ground, lordship, and that another
Where
judgment that
there is no mention about the.
lordship. That it was mentioned that he was arrested on 21/7/2018 and continues to be in custody. Chitta Biswas, middle portion, your lordship will find.
No, but the order is silent that
Or
that the bail was granted only on ground of.
that specific, it is not there, lordship, and that just again I'm taking.
Then how will we follow it? Unless.
Ravi Prakash is there, your lordship. And this Ravi Prakash. Paragraph 4. Paragraph 4, Lordship, may I kindly see?
Yes,
And one copy of your Lordship's order where your Lordship has dealt with all the judgments relating to those delayed trial, Lordship. From para 11 onwards.
yes, Mr. Bova.
My lord, may I take your lordship to my lord, page 22 annexer 1, this is the FIR lordship.
Yes,
My lord, may I read lordship? With reference to the subject cited above, I have the honor to report you that today on 25/8/2022 at about 11:50 AM, received an information that 4 person along with 7-8 bags get up on a passenger magic at Kothaltoli magic stand. They may be carrying ganja in their bags. Normally, accordingly, the information has informed the other person lordship. Then, my lord, next paragraph, at around 12:15 PM, I arrived at Kothaltoli Bazaar magic stand and saw 4 persons along with their luggage get up on a passenger magic vehicle bearing registration number so and so to proceed towards Pathakandi. I have asked them to produce their luggage. Accordingly, they produced 8 numbers of bags. After conducting self-search in presence of the independent witnesses, I started the search of 8 numbers of bags in presence of independent witnesses. Now, lordship, all the person, lordship, they were traveling together and they carried the my lord contraband, my lord, together. But it was my lord in their separate bag, lordship, they have carried the contraband. And that is why lordship will find at page 24 lordship. The FIR has been registered, my lord, under section 20B2C oblique 29 of the NDPS Act. My lord.
no, that is the submission.
Yes.
What material is there?
My lord, if there is no 29 lordship, if the FIR has not been registered under section 29 of the NDPS Act, my lord, then lordship, he can take a plea that lordship, there was no murder conspiracy, lordship.
No,
Now, lordship, it is a search-sheeted case, lordship. It is a search-sheeted case. Trial has already proceeded, lordship. Already 2 witnesses have examined, lordship. Now, lordship, on 11/7/2023, charges frame, lordship. Thereafter, lordship, 1 PW examined on 13/9. The next PW2 was examined on 7/11/2023, my lord. And they have implicated, lordship, that they were traveling together, lordship. Now, whether they were traveling together or not, lordship, that is the, my lord, that will be decided by the trial court, lordship. Now, there is a prima facie case or not, my lord. That is has to be looked into by this honorable court, my lord. If section 29 is not there, lordship, that the matter would have been different, lordship. That there is no conspiracy, my lord.
no. What materials are there?
Because they were traveling together, lordship.
But in Amar Singh's case, the Supreme Court has said that merely by traveling together in the same vehicle would not attract 29.
My lord, that has to be looked into by the, my lord, trial court only because evidence is going on, lordship. We are only, my lord, we can submit only on the basis of the search sheet, lordship, and the other materials, my lord.
No, is there any other statement of witnesses to show that there was conspiracy?
My lord, they were, my lord, boarded the Tata Magic in Patharkandi and they are supposed to go to Bihar, lordship, carrying their contraband, lordship.
No, apart from finding them in the same vehicle,
My lord,
apart from finding them in the same vehicle,
my
Tata
lord,
Magic vehicle,
my lord.
what else is there
My lord,
to
then,
show
lordship,
that there was
So that is my lord, clear from the search, lordship will find it.
That there was a criminal conspiracy.
Yes, because they were traveling together, lordship, in the same vehicle, carrying the same contraband, lordship. They were all carrying ganja, lordship, but in a separate bag, so that it not become the commercial. And entire quantity, lordship, from the 4 persons, it becomes a huge commercial, lordship.
No, then
Every 3
what
kg.
is your counter to the submission that in Amar Singh's case,
My lord,
Supreme Court said that merely by traveling together, apart from finding them in the same vehicle, there has to be some other evidence.
then lordship might do one thing, lordship fix it tomorrow, lordship, I'll again go to the scan copy. Tomorrow,
Go through. You,
because lordship, at this stage, the trial is going on, lordship, because we cannot say, lordship, these
no,
witnesses
they
have
are
said
only
this.
praying for bail. Apart from this, they have additional submission of prolonged incarceration.
There is no prolonged interconnection, because lordship, charges frame on 11/7, my lord. Then PW1 examine on 13/9,
Okay, you go
PW2
through this,
examine on, my
go
lord,
through the material scan copy.
my lord.
Is there any other material apart from finding them together
My lord,
to show that there was a criminal conspiracy between accused number 1 and accused number petitioner 1?
my lord,
Because if that 29 is not there,
my lord.
then Amar Singh has to be followed.
My lord, let it be a day after tomorrow, lordship, Wednesday, my lord.
Okay.
Tomorrow, lordship. Then, my lord.
Heard Mr. A. Ahmed, learned counsel for the petitioner. Also heard Mr. R.J. Barua, learned additional public prosecutor, who prayed for some more time to go through the scan copies of the case reports available before this court to find out as to whether there is any incriminating material to implicate the present petitioners under section 29 of the NDPS Act on law. The prayer is allowed. Let this case be listed again on tomorrow or day after.
I am paying for day after tomorrow, but yes. And lordship, like,
have
I
to
also
go
request my counsel to my furnish the, my lord, copies of the, my lord, citations he has relied on, my lord.
I will give him
No,
by today.
Let it be day after tomorrow.
Day after
Let,
tomorrow.
let him go through. Let this case be listed again on 3rd of April
Alright.
as part third matter.
Alright.
Finding item number 9.
Lordship, noting maybe.
Heard Mr. H. Islam. Also heard Mr. R.J. Bora, learned additional public prosecutor.
CD.
Call for the case diary and issue notice to respondent. Issue notice to opposite party number 2 as per the mode prescribed in the case of Deepak Naik versus State of Assam by a division bench of this court. The petitioner shall take steps. The officer in charge of Gauripur Police Station shall submit the service report of notice issued to the respondent number 2 through this court through learned additional public prosecutor before next day. Let this matter be listed again on
19/4.
19/4/2000.
Item 12.
Prior, Lordship takes up the matter, Lordship. Today is a date fixed in the trial court, Lordship.
What is your prayer?
Lordship,
What is your prayer?
Lordship would like to see that any witness PW turn up today or not.
This is a NDPS case,
NDPS commercial.
commercial quantity.
Only the ground is that the long incarnation, Lordship, that 568 days, Lordship. Altogether, Lordship, matter has been charge sheeted, Lordship. 6 witnesses are there, Lordship. 4 were examined, Lordship, long back, Lordship. And till then, Lordship, the subsequent, these two witnesses, Lordship, did
No,
not turn
what,
up with the court.
on what ground you are paying for
That Lordship detention, Lordship.
long detention?
Lordship, only that ground, Lordship. Because recovery was there, Lordship, from that, regarding the merit of the case, Lordship, that, the recovery was there, Lordship, charge sheet was submitted, Lordship, against this present petitioner, Lordship, and 4 has been turned up in the court. Lordship.
Out of 6 witnesses, 4 already examined. Lordship.
Let 2 other be examined. And
Okay, but,
otherwise, 568 is less than 1.5 year.
1 year, 6 months, Lordship, more than 1.5 years. Thursday, sir, no? It is fixed on Thursday, Lordship, if possible, Lordship, then,
Mr.
after instruction.
Heard Mr. S. Munir, learned counsel for the petitioner. Also heard Mr. R.J. Barua, learned additional public prosecutor. Learned counsel for the petitioner submits that the
Order, Lordship, on.
case, the special NDPS case number 89/2022 is fixed before the trial court on when it is fixed.
Today itself. Lordship. Last part, Lordship, fixing 1/4/2020.
When is the date of evidence?
The last part, Lordship, that I have given the order sheet to print out of
Fixed
the.
today before the trial court for further evidence. It is also submitted by learned counsel for the petitioner that out of 6 witnesses, 4 have already been examined.
Lordship.
Therefore, he prays for some more time to see as to whether any witness is examined in the trial court today or
No, only today, Lordship. Let it come on Thursday, Lordship. I'll produce the order, Lordship.
In the meantime, up to the status report may be called for.
No need, Lordship, there only the order will reveal, Lordship, if any PW has been.
learned
examined.
counsel also submits, learned counsel for the petitioner also submits that he shall produce the order of the trial court passed today on the next date fix and prays for listing this case on some other day.
Only on 4th, Lordship. Because today itself we will come to know, Lordship, that
5th, let it be on 5th.
4th, Lord. 5th, Lordship.
Let this case be listed again on 5th of April.
Lordship. Much obliged. Much obliged. Much.
My senior is on Lex in court number 7. Kindly pass over the matter for time.
It is also NDPS.
Yes, Lordship. It is NDPS, Lordship, and case was intercepted on 2/2/2021. About Lordship, 3 years, 1 month, Lordship.
Let him come. Let me secretary.
As usual, Lordship.
We'll take it up.
Much obliged.
Lordship. 439 application, Lordship. He is in custody. Here, Lordship, total 3 persons were named in the FIR. Out of them, 2 are already on bail, Lordship. That FIR, Lordship, will find page 10.
Yes.
So just I'm taking your Lordship to last paragraph, Lordship, may I kindly see.
Yes.
During the NACA checking about 2:40 AM, one TVS scooty bearing registration number so and so was intercepted with the help of PS staff at Bogota, Boilamari, PWD Road, loaded with 2 numbers of jute gunny bag. On asking the rider of the scooty, he disclosed his name and address as Rantu Das. He is the present petitioner before your Lordship. Rantu Das, Afterwards, the two jute gunny bags are opened and found 4 numbers of white plastic packet containing dry plant material suspected to be ganja inside bags. Accordingly, the recovered 4 packets of plastic carry bag were weighed using digital weighing machine in presence of independent witnesses, and the net weight of suspected ganja with polythene bag was found total 20 kg. So from him, it was 20 kg. Afterwards, the above mentioned all the recovered items along with Scotty and mobile handset were seized as per seizure list in presence of witnesses observing all the formalities. So now next paragraph, Lordship may kindly see how his book, page 11, second paragraph I am reading, Lordship. Further, it is mentioned herewith that during the spot interrogation, apprehended person, namely Rantu Das, revealed that he worked with Ridip Kumar of Baramboi, and today he asked him to transport the seized ganja from an unknown van to Japia to his house. Accordingly, on the basis of his statement and on being led by Rantu Das, we proceeded to the house of Ridip Das. So just here pausing for a moment, Lordship. Lordship, I kindly appreciate one thing that Rantu Das, present appellant, said that he worked with Ridip Das and he led the police party to the house of Ridip Das. Because I'm pointing here because Lordship will subsequently find that articles were recovered from someone else's house, not from this Ridip house. So, on being led by Rantu Das, we proceeded to the house of Ridip Das and conducted search in presence of independent witnesses and found one white color plastic bag containing dry plant material suspected to be ganja in the house of Gautam Kumar. I led them to the house of Ridip Das and they found the subsequent contraband from the house of Gautam Kumar, son of so-and-so, so-and-so. Accordingly, he recovered one packet of plastic carry bag was weighed using digital weighing machine in presence of independent witnesses, and the net weight of suspected ganja to be found to be 4.2 kg. Afterwards, from him 4.2 kg was recovered, and trial court granted him bail considering that there is no abatement or conspiracy. So
Trial court granted bail
Gautam
to,
Kumar.
and
Gautam Kumar
why
and
your bail was rejected?
Ridip Das.
my bail was rejected on the ground that it is commercial quantity. But my assumption is that if it is above 20 kg, then it will be commercial quantity.
Yes.
Otherwise, it will be intermediate quantity.
20 kg is commercial.
That definition, just I am taking your Lordship
Where
to
is the definition of commercial?
definition you will find 2(7)(a), small a.
Two,
7, Roman 7, small a.
greater than.
Yes, commercial quantity in relation to narcotic drugs and psychotropic substance means any quantity greater than the quantity specified by the central government by notification in the official gazette. So in schedule it is 20 kg. So it has to be greater than 20 kg. Then it will be commercial.
20 kg is commercial.
It has to be greater than that 20 kg, more than 20 kg. And that 20 kg is including polythene pack. How long you are in?
I am in custody since 15/1/2023, Lordship.
Now, what is the stage of the trial?
Lordship, already Lordship, out of Lordship,
442.
out of 6 PWs, Lordship, 2 were examined, Lordship. PW 1 was examined on 3/11/23 and PW 2 on same date, Lordship. And next date is fixed for 18/1/24 for production. Maybe some development has been made, Lordship, but the scan copy was called here earlier, so it was here only, Lordship.
Have you taken this plea before trial court, this 20 kg?
That observation, Lordship will find that it was held that it is commercial quantity, so section 37 will be attracted, Lordship.
Where is that order?
Rejection order, it was there, Lordship, just I'm placing.
And where is the order of granting bail to the co-accused?
That your Lordship on page 28.
That is lordship, intermediate lordship. Only 4.5 exam.
Yes, Miss Begum.
Lordship, let us bring the status report, Lordship, up-to-date status report. Already 2 witnesses are examined, Lordship.
What
That
will
is the
happen?
20 kg.
Their plea is different. Their plea is
Lordship,
that,
we have not taken that plea in the trial court, Lordship, that it is intermediate quality, Lordship.
yes, but he's taking that plea before this.
So, Lordship, then at least, Lordship, let me bring the status report, Lordship. Because with the evidence are going on, Lordship. And it is on time, Lordship.
Lordship, may dispose of my case on merit itself. I'm not on other.
On the.
On the materials
Because-
which is before your Lordship. On either way, your Lordship may dispose of. Because my cases are only 20 kg recovered and that will not fall within Lordship commercial quantity. And other 2 accused persons were granted bail that they have not challenged till date.
Heard Mr. A. Ahmed, learned counsel for the petitioner. Also heard Miss A. Begum, learned additional public prosecutor. This application under section 439 of the Code of Criminal Procedure, 1973, has been filed by the petitioner Rontu Das, who has been detained behind the bars since 15/1/2023 in connection with special NDPS case number 19/2023 pending before the Court of Learned Special Judge Kamrup Amingao and corresponding to Hajo PS case number 28/2023 registered under section 20B2C/20B2B/29 of the NDPS Act, 1985. The accusation against the present petitioner is that on 14/1/2023, one Vishnu Jyoti Bora, SI of Police of Hajo Police Station had lodged an FIR before the officer in charge of Hajo Police Station, inter alia, alleging that on the basis of reliable information received that huge quantity of ganja would be transported from Japia side to Boromboi, Bakta side. A Naka checking was conducted by the Hajo Police Station, and during the Naka checking at about 2:40 AM, one TVS NTORQ scooty bearing registration number AS 25S 7874 was intercepted at Bakta PWD Road, and 2 numbers of jute gunny bag containing suspected ganja was seized from the possession of the present petitioner Rontu Das. On weighing of the suspected ganja, the total weight of the ganja along with the polythene bag was found to be 20 kg. Later on, the present petitioner during interrogation led the police team to the house of one Pradeep Das, where search was conducted. Stop. Thereafter, during search operation, in the house of one Gautam Kumar, 4.2 kgs of ganjas was recovered. Stop. On receipt of the said FIR, Hajo PS case number 28/2023 was registered. Stop. Ultimately, after completion of the investigation, charge sheet was laid against three numbers of accused persons, namely the present petitioner, one Gautam Kumar and one Rideep Kumar under section 20 within bracket small b within bracket small Roman 2 within bracket capital C, as well as 20 B2B and 29 of the NDPS Act. Learned counsel for, where is the bail order?
That lordship, I'm having a certified copy, lordship. That rejection also is granted.
The granting of the bail.
Granting bail, your lordship will be on page 28. Page 20.
This bail was granted during trial or during investigation?
During investigation.
During the course of investigation, the court of learned Special Judge Amin Gao granted bail to the other two co-accused on the ground that the quantity of ganja seized from their possession was of intermediate quantity.
No, he was granted bail because nothing was recovered from him, lordship, Rideep Kumar.
And other one?
Other one, that lordship order I could not get, lordship, that's date in there.
This 20 kg is recovered from this present petitioner, lordship.
No.
From
No, the question is whether 20 kg,
20 kg is commercial, lordship.
make me understand how.
It's fall under the commercial category, lordship.
Show it.
Schedule
You go to section 2. Section 2, Roman 7A, where the commercial quantity is defined. Read that. Read it, Miss Begum.
but in the schedule, lordship.
No, first read
Lordship.
it so that I can also hear.
7.
7A, where commercial quantity is.
in relation. Commercial quantity in relation to the narcotics, drugs, and psychotropic substance means any quantity greater than the quantity specified by the central
So
government by the
it mentions that quantity greater than the quantity mentioned in the
schedule.
Now, what is the quantity mentioned in the schedule?
20 kg.
So it has to be greater than 20 kg. So 20 kg cannot be greater than 20 kg. What is your submission?
Lordship.
So 20 kg is not the commercial quantity.
Lordship.
What was the last line? No, that no ganja was seized from his possession. No. cut this line. That no ganja was seized from his possession. Learned counsel for the petitioner has submitted that from the seizure list, it becomes clear that the quantity of ganja seized from the possession of present petitioner on weighing along with the polythene bag was found to be 20 kg. And as per section 2 within bracket Roman 7, Roman 7a, the commercial quantity has been defined in relation to narcotic drugs and psychotropic substance as any quantity greater than the quantity specified by the central government by notification in the official gazette. It is further submitted by learned counsel for the petitioner that ganja is that in column number 6 of the notification by the central government, column number 55 of the notification issued by the central government, the quantity mentioned in column number 6 against ganja is 20 kg. Therefore, it is submitted that for becoming commercial quantity of ganja, the weight of the seized contraband has to be more than 20 kg. Stop. You are conceding,
Lordship, my objection may be.
though learned additional public prosecutor objected to the grant of bail to the present petitioner. However, the submission of learned counsel for the petitioner seems to be persuasive, as apparently the quantity of ganja seized in this case is found to be of 20 kg when weighed along with polythene bag. So it is not a quantity greater than the quantity mentioned in the notification published by the central government. Therefore, prima facie, it appears that the contraband seized from the possession of the present petitioner in this case is not of commercial quantity, but of intermediate quantity. As the petitioner has already been detained behind the bars since 15/1/2020, 2023, this court is of considered opinion that he is entitled to be released on bail. Accordingly, the petitioner, namely Rontu Das, is hereby allowed to go on bail of rupees 50,000 with one surety of like amount, subject to the satisfaction of the trial court with following conditions: that he shall, number one, he shall regularly appear before the trial court as and when so required by the trial court, and shall cooperate in the trial pending against him. Stop. Next, he shall not directly or indirectly make any inducement, threat, or promise to any listed witnesses or any other person who may be acquainted with the facts of this case. Number 3, he shall not indulge in any offense similar to what similar to that for which he has been charged in the special NDPS case number 19/2023. With above observation, this bail application is hereby disposed of.
Obliged, Lordship.
Lordship, in this case, Lordship, instruction was called for Lordship for the search sheet number, Lordship. And search CS number is 09/24.
Charge sheet is laid.
Late, sir.
It is late, Lordship. We'll file a bail application before the trial court now.
Okay. Heard Mr. M. Ahmed, learned counsel for the petitioner. Also heard Ms. A. Begum, learned additional public prosecutor, who submits that in this case, charge sheet has already been laid, bearing charge sheet number
09/23, dated 16/2/20, 09/24. Oh, no, 23.
dated
Lordship, sorry, Lordship, it's 09/24, dated 16/2/24.
in view of the laying of the charge sheet. The counsel for the petitioner has submitted that he would, you are withdrawing,
No, we
we
don't.
will, we are dismissing.
Also, we close this application and we will
This
close the
bail
trial.
application is closed with an observation that the petitioner may approach the trial court and may seek relief before the said court to which he may be found entitled to.
Yes.
Item 16.
My finger is still on legs in court number 7.
2 years.
2 years and 3 months, my lord.
What is your prayer?
Lordship, kindly pass over the matter for timing.
Let him come.
Can it be fixed at 2?
At 2, Lordship, another matter is fixed at 2.
After that matter, we'll take it up.
Okay, Lordship.
Obliged.
My subject. Oh, 17.
Item 17.
Lordship, same prayer.
We need a special court for NCB,
Yes, ma'am.
or NCB has to increase the number of standing counsels.
My lord. 439 application, my lord, the trial going case, my lord.
No, they are paying for
My lord,
passing over for the
till
time.
today, my lord, 2 years, 7 months, 12 days completed, my lord, behind the bar, my lord. And even there is only 2 number of witness, my lord. Till today is pending, my lord.
We'll take up at 2 after those 2 matters.
Obliged.
My subject.
Item 18.
From 160.
There is an order dated 30/3/2024, my lord.
Production. Lordship, this case has been search seated, Lordship. 164 is there, Lordship may peruse that 164, Lordship.
What order was 13/3? You are mentioning about some order.
The order passed by this honorable court, my lord. That is
For scan copy.
13/3/2024. Mr. Bower submits that he has not received the case diary, but as per his instruction, IO has completed investigation
Search sheet file.
and submitted charge sheet, being charge sheet number 38 of the 2012, dated 29/2000, under section 365, read with section 4 of this code. That since the charge sheet has been submitted under section 4 of the POSCO Act, notice has to be issued, there's one but two. But we have taken steps. Steps be taken by the register.
From the concerned jail superintendent by the last order. The Azhar is at page 11. I am not named in it. Order, my lord, ground
Since
taken,
when you are in custody?
9/2, my lord, 9th of
9/2.
February.
What is the allegation?
Allegation, your lordship, that is been brought against me is available only in the forwarding report, my lord, since I was not named in my lord, Ejahar.
Who are you? What do you do?
My lord, I am a petty businessman,
Businessman.
petty business.
Okay.
At page 23, my lord. 922024, my lord. The grounds given at the bottom,
You make forged government documents.
that is the allegation brought against me.
Okay.
At clause 2, during investigation found that the below noted arrested accused person involved in making of forged government documents.
How many days have lapsed since the date of
52 days.
52 days?
Mandatory is perhaps 60 days, my lord. And my lord, my co-accused, next page, your lordship will see page 24, who is also named in his forwarding report, my lord, at clause 7. Sri Jibon Medhi. He is granted bail order, my lord, in an anticipatory bail application, my lord, by this honorable, your lordship's order. And the other ground we had taken, my lord, that 41A was not complied with.
In this case,
Yes. Ernest Kumar is quite explicit, my lord, on this. There was 7.
yes, Mr. Shah.
My lord, CD received, my lord, here. And regarding his involvement, my lord, some of the witnesses, my lord, said regarding his involvement, my lord. One also co-accused, my lord. His name is here, my lord, Jibon Medhi. Jibon Medhi, my lord.
He is granted bail.
My lord. He also implicated the present petitioner, my lord, from the statement of his, my lord.
What was the statement? What,
My lord,
what
not
he has
making
done? No, just you can tell me what he has done.
my lord. My age is 45 years and I am daily wage worker. Few months ago, I met some persons from the company who were asking me to do a job of security in their company. But later, I was not called by them. Mr. Raju Ahmed made forged documents and later gave it to me for the land scam. They are all of them involved in the land scam, my lord. They have prepared forged documents and sold to the different persons. Their names are different. And they have
What forged document?
my lord, forged Shri Vidya Pator and Muhammad Raju Ahmed are involved in several landscape case and they fraud innocent people by cheated them.
But these are general statements.
My lord,
These are general statements.
my lord,
No
statement.
specific.
No, my lord, but from the statement of the
Any specific allegation that
no specific such type of my lord, but from the-
otherwise also he has been detained behind the bar for 50.
my lord, only on the
Now, may I place a copy of the order granted to the co-accused?
Any specific allegation
no,
against?
my lord, but not my lord. From the statement of the it is revealed that he is also involved in the scam, my lord.
Now, do you require him for further interrogation?
My
Do
lord,
you need him?
my lord, here also IO has my lord submitted one bail objection, my lord.
What is this?
My lord,
Why he is
if
opposing?
the accused on bail, he may be a hamper and temper the investigation, my lord. Prosecution witness, my lord. Arrested, other accused person are yet to be arrested, my lord. For further investigation of the case, he is need, my lord. There are more facts which is needed to be unfold for further investigation of the case, and if he release bail, the chance of hamper the investigation, my lord.
Heard Mr. B.D. Goswami, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. This application under section 439 of the Code of Criminal Procedure, 1973, has been filed by the petitioner Raju Ahmed, who has been detained behind the bars since 9/2/2024 within bracket for last 52 days in connection with Jagirot PS case number 300/2023 under section 420/406/468/471 of the Indian Penal Code. The gist of accusation. Where is the FIR?
FIR is long. It's a very long piece FIR, my lord. Page 11. But I am not reached.
One Nitul Ahmed who has taken 48
Das,
lakhs,
Nitul
Nitul Das,
Das.
who has taken 48 lakhs from the company, my lord, giving land, my lord. Thereafter, other part
The-
came in, my lord.
The gist of accusation is that one who is the informant name?
Is a company, my lord, Longspan Structures. My lord. At
Who is-
page 17, it is done by authorized signatory for Longspan Structures Private
The
Limited.
authorized signatory of Long Span Structures Private Limited had lodged an FIR before the officer in charge of, before the superintendent of police, Morigaon, on 27/9/2023, complaining against forgery of government records by one Nitul Das. Stop. The name of the present petitioner has not been mentioned in the said FIR. However, in the forwarding report dated 9/2/2024, filed by the investigating officer of the Jagirod PS case number 300/2023 at the time of production of the present petitioner after his arrest before the court of learned Chief Judicial Magistrate. It was alleged therein that the petitioner was found involved in making forged government documents, including NOC, sale deeds, power of attorneys, etc. Now, what is your submission? These are
No, my lord, one other ground also they had taken. My lord, I had taken that ground that 41A was not complied with.
yes.
And number two, my co-accused has been granted anticipatory bail. And they said that I am a habitual offender, and so 41A is not, my lord, necessary under the circumstances. But my lord, I had produced a document on the last occasion, my lord. I had submitted a copy of an order of this honorable court in a petition filed by him, my lord. And in which, my lord, I have got my copy. One copy was given earlier.
Yes.
10/1/24, my lord. Wherein in the second page of the order, pursuant to the order of this court dated 22/12/23, the learned additional P received a report from the officer in charge of Jagirod P, that is the concerned police station, man, where I live, and placed the same before this court and submitted that the officer in charge has confirmed that no FIR is pending in Jagirod against the present applicant, that is Raju Ahmed, man. So even in any case, my lord, I am not a habitual, it appears, man.
Now, where it is stated that because you are a habitual offender.
That is not said, but there is no case in the concerned. Oh, in the forwarding. In the forwarding. Your lordship will kindly see page 24.
What is the law?
Third paragraph, my lord. May I read out?
No, what is the law? Whether habitual offenders need not to be given 41A notice?
No, my lord. There is no such thing. My understanding is quite clear, my lord. Para 7.
Okay. Learned counsel for the petitioner has submitted that the allegations leveled in the forwarding report submitted that the petitioner has not been named in the FIR, and the allegations leveled in the forwarding report against the present petitioners are not true.
Yes.
It is also submitted by learned counsel for the petitioner that at the time of arrest of the present petitioner, the mandate of complying with the provisions of complying with the provisions of section 41A of the Code of Criminal Procedure was not followed in violation of the guidelines of the apex court in the case of Anesh Kumar versus
My lord, 2014 8 SCC.
Anesh Kumar versus State of Bihar,
Man,
reported in
2018,
Reported
2008.
2014 8 SCC 273.
Para 7, 11 and 12.
Learned counsel for the petitioner has also submitted that one of the co-accused named in the forwarding
Please,
report,
Gibbon Medhi.
namely Gibbon Medhi, has already been granted anticipatory bail by this court by order dated 5/1/2024, passed in AB case number 3928/2023. Learned counsel for the petitioner has also submitted that though in the forwarding report, the officer forwarding the accused before the court has stated that the mandate of section 41A of the Code of Criminal Procedure was not followed, as the petitioner was a habitual offender. However, there is no other case. However, no other case is pending against the petitioner in the Jagirod police station, as appears from the observation made by a coordinate bench of this court in AB case number 4354/2023 in order dated 10/1/2024. Learned counsel for the petitioner has also submitted that considering the period of detention already undergone by the present petitioner, also he may be allowed to go on bail. It is also submitted that the petitioner would cooperate with the investigating officer during the course of investigation. On the other hand, learned additional public prosecutor objected to grant of bail on the ground that there are incriminating materials against the present petitioner on record. And even the co-accused have given implicating statement against the present petitioner. Stop. I have considered the submissions made by learned counsel for the parties as well as perused the materials available on record, including the case diary of Jagirod PS case number 300/2023. It appears that the reasons shown for non-complying with the mandate of the 41A, with the mandate of the section 41A of the Code of Criminal Procedure, 1973, in the forwarding report by the arresting authority are not valid ground. Same may not be ground for not complying with the guidelines of the apex court in the case of Anesh Kumar versus State of Bihar and another within bracket Supra. The petitioner is entitled to get bail on that ground alone. Otherwise also, considering the fact that the petitioner has been detained behind the bars since last 52 days, this court is of considered opinion that further custodial detention of the present petitioner may not be necessary for fair completion of the investigation of Jagirod PS case number 300/2023 if he cooperates with the investigating officer. Stop. In view of above reasons, the the petitioner, namely, what is the name?
Raju Ahmed.
Raju Ahmed.
Raju Ahmed is hereby allowed to go on bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of learned Chief Judicial Magistrate Morigao with following conditions. Condition number 1 and 2. You will cooperate in the investigation. With above observation, this anticipatory bail application is hereby disposed. This bail application is hereby disposed of.
CDB return back.
The case diary be returned back.
Apply.
Item 20.
Mayor,
Itu that Ramesh Kumar Asile. Yes,
Mayor, the petitioner, madam, before your lordship, madam, is a 19 years old boy, madam.
90
19 years, madam. And
quantity of contraband.
My lord, CD received, my lord, without the FSL report, my lord.
What was the contraband?
Contraband, my lord. From his possession, my lord. This is from his possession, my lord. 37 grams, my lord.
37.
Suspect, 37 grams, my lord. Suspected heroin, my lord. It was seized from his possession, my lord. And the FSL report yet to receive, my lord. I pray for short my lord, next week,
No, FSL, assuming that it is heroin,
my lord,
we will proceed on that pretext.
my lord,
That assuming the contraband to be heroin,
my lord.
what is the progress in the
My lord,
investigation?
investigation is going on, my lord. Here some of the witnesses examined, my lord. And he himself in his statement also admitted that he has the business of, my lord, transporting the, my lord, contrabands, my lord. He also said that he has sold the drugs, my lord. Which related the drugs business, my lord. Peddler, my lord.
He's a daily laborer. He used to work in the various places,
But
in Guwahati, Poco area, Soigao area.
But their business is not to peddler, my lord,
And
not
the,
to transport the drugs, my lord.
The contraband was seized from the bus, not from the petitioner. It was in the cabin of the bus. Some bags, luggages are there. It is not conscious possession from the petitioner. In any case, 47 days in custody, my lord.
How many days?
47 days. Daily labors, my lord, having 4 children, minor children.
This is a 60 days offense.
My lord.
Any condition.
21 B, my lord.
This is item number 20.
21.
21, my lord.
Heard Mr. M. U. Mondal, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. This application under section 439 of the Code of Criminal Procedure, 1973, has been filed by the petitioner Abdul Qayyam, alias Muhammad Abdul Qayyam, who has been detained behind the bars since 15/2/2024 within bracket for last 47 days in connection with Soigao PS case number 62/2024 under section 21B of the NDPS Act, 1985. The gist of accusation in this case is that 1. Ujjwal Kumar Das, SI of Police of Soigao PS Police Station, on 15/2/2024 had lodged an FIR before the officer in charge of Soigaon Police Station, inter alia, alleging that on that day, on receipt of reliable information through secret source that some narcotic drugs would be carried in a night super bus bearing registration number AS01FC 3133, a Naka checking was conducted at Kukurmara under Soigaon Police Station. And during the Naka checking operation, the night super bus bearing AS01FC 3133 was intercepted at Kukurmara, and during the search operation, 3 packets of 3 pouch containing brown colored substance suspected to be heroin was found inside a bag from the possession of the present petitioner. On weighing of the said contraband, it was found that the weight of the, it was found to be, on weighing of the said contraband, it was found to be 37 grams. Stop. What is your submission, Mr.?
Well, it was not from the conscious possession of the petitioner. It was found in the marketing bag.
That bag
kept
does
in
not
the
belong.
kept in the buses, where the luggage are put.
Whether it was your bag.
That was not my bag.
It is
It
not.
was
not
his
my
bag.
bag. I have been told.
Learned counsel for the petitioner has submitted that the contraband was not found from his conscious possession, as it was found in a bag which does not belongs to the petitioner. It is also submitted that the maximum period of detention, maximum period for which the petitioner may be detained under the offense, for offense under section 20B, 21B is 60 days, whereas the petitioner has already completed 47 days behind the bars. On the other hand, learned additional public prosecutor has produced the case diary of Soigaon PS case number 62/2024 and has submitted that there are incriminating materials against the present petitioner in the case diary. However, the investigating officer has not yet collected the forensic laboratory report. Stop. He has opposed the grant of bail to the present petitioner.
Yes, he has also admitted that he is the murderer.
It is
Yes,
also
sir.
submitted that the petitioner in his statement under section 161 of the Code of Criminal Procedure has admitted that he used to peddle the drugs.
Right.
Stop. I have considered the submissions made by learned counsel for both the sides and have perused the materials available on record. Though there are incriminating materials against the present petitioner in the case diary. However, considering the progress made in the investigation, as well as considering the fact that the petitioner has been detained behind the bars for last 47 days, this court is of considered opinion that his further custodial detention may not be necessary if he otherwise cooperates in the investigation. Stop. In view of above, the petitioner Abdul Qayyam is allowed to go on bail of rupees 30,000 with one surety of like amount to the satisfaction of learned Chief Judicial Magistrate Kamrup. No, to the satisfaction of learned Session Judge, Special Judge Kamrup with following conditions. Number 1 and 2, and number 3 would be, he shall not indulge in
Such type of activity.
any similar offense during the pendency of the case. Now, he shall not indulge in any similar case offense with which he has been accused of in this instant case. Stop. With above observation, this bail application is hereby disposed of. Send back the case.
My lord.
Developers.
Item 22.
These two applications are against the same accused, madam, and CD was called for, madam. My charge seated case, madam. Sorry, I'm sorry.
Same accused means?
My lord, accused is one, my lord, who has filed two petitions in two cases, my lord, in the same
No,
police
now we
station.
are taking up now item 20, item 22 only.
22 is the one which is, my lord, I have been shown arrest.
Okay.
And the 23 will be the right case, my lord, that is the first case, my lord.
23.
3 years, my lord, next case. Page 11 is the annexure one. That is the Ajaha, my lord. I preferred bail below, my lord, that was rejected.
Why
Ajaha
why
is in
two
page
cases,
11.
two different
My lord,
incident?
20,
Incident are different, but the victim is also different, but the
Accused
charges
is-
are more or same. Accused is the same person, lordship.
Then why these are clubbed?
my lord,
Why both these cases are
no,
Not-
different, separate case. my lord.
separate cases?
Separate case.
So we
In,
can
in one, I was arrested, and in the other,
You
the
are-
first
you were
one, I was shown.
shown
arrest.
it.
Yes.
So first we'll take up
The-
23.
23, man,
Okay.
page 11.
Yes.
May I read, my lord? With utmost respect, it is informed me that my daughter Sangita Bora frequently visits the shop of the below named accused for purchasing various things. It's a neighborhood shop, my lord. Taking advantage there of the accused person since long has been attempting to commit.
Now,
rape.
what stage is this case is pending?
Evidence.
Investigation,
It's fixed for evidence on,
evidence.
Evidence.
yes, my lord.
2/5/24.
Okay, since when you are in jail?
My lord, since my lord 30th of September, first of October,
1st October.
yes. 23, my lord.
What is the stage of investigation?
Fixed for evidence now.
Whether
Right.
victim has been examined?
My lord,
Informant
medical
and-
report I have my only, not in the court, madam. We have annexed the copy of the medical report. Page 21, madam. Dated 6/10/2023. Annexure 3. Your lordship will kindly note the opinion at the bottom, page 21.
Item is to item number 13. Item 16.
We'll wait for some time. Let Mr. KL come. Let him come.
Item 24. May please, your lordship.
Charges submitted, lordship.
Yes, lordship. Length of detention, your lordship, kindly be considered, your lordship. 24 to 2020. For your lordship, he was arrested, your lordship. Only allegation, your lordship, 120B 420,379, your lordship. Actually, in this case, your lordship, 379 has not come as per FIR, your lordship. 38 days behind the bar, your lordship.
No, you have to approach the trial court.
Kindly observation given, your lordship.
Heard Mr.
Yes, yes, sir.
S. Islam, learned counsel for the petitioner. Also heard Mr. K. Das, learned additional public prosecutor. Though the case diary was called for, however, learned additional public prosecutor has submitted that in the meanwhile, charge sheet has been laid bearing charge sheet number
65/2024 dated 25/3/2024.
in view of the laying of the charge sheet. This bail application is disposed of with an observation that the petitioner may approach the trial court and may pray for bail before
That bill application will be considered, your lordship.
before the same said court, which shall be considered as per law.
Considered, your lordship. As per law, your lordship.
Not as per law.
No. Considered, your lordship, 38 days here.
It will be otherwise, if you file an application before a court,
Yes, sir.
it will be otherwise considered.
38 days, your lordship.
It may be allowed, it may be rejected.
Lordship, length of detention, your lordship. There is no.
No,
provision.
as after laying of the charge sheet, at the first instance, the trial court is the best court to consider your bail application. Therefore, I have observed, approach the trial court and make prayer before that court.
Discretionary power up to you, lordship. Lord, your lordship.
I have passed the orders.
Item 26. All right, your lordship.
None has appeared for the petitioner on call. Let this case be listed on 4th of April.
Charge sheeted, lordship.
It has been charge sheeted. Let us see on 4th of April.
Item 57.
Charge sheet submitted, lordship.
Heard. Mr. A.O. Basumatari.
Yes, my dear.
Learned counsel for the petitioner. Also heard Mr. K. Das, learned additional public prosecutor, who has submitted that though the case diary was called for, however, in the meanwhile, the investigating officer has laid the charge sheet bearing charge sheet number
83/2024 dated 22/3/2024.
in view of laying of the charge sheet. The petition, this bail application is hereby disposed of with an observation that the petitioner may approach the trial court and may pray for regular bail before the said court, if so advised.
I am sorry to say, my lord, regarding item 26, my lord.
It will be called item 26
Yes, my
of 4th April.
lord. For that will be given, my lord. City was called for, my lord. I think must probably start in the 15, my lord. But today, my lord, I am 69 days in the behind the bar.
But charge sheet has been laid.
Sashi?
Charge sheet has been
Charge sheet.
submitted. You
Yes.
pray before the some heard Mr.
F.A. Hassan, my lord.
F.A. Hassan, learned counsel for the petitioner, also heard Mr. K. Das, learned additional public prosecutor, who has submitted that though the case diary was called for, however, in the meanwhile, charge sheet has been laid Stop. In view of the laying of the charge sheet, this bail application is disposed of with an observation that petitioner may approach the trial court and may pray for regular bail before the trial court, if so advised. With above observation, none, but if so advised, stop.
May it please your lordship. Lordship, this is a 439 bail application, lordship. We have 20 days in jail custody, lordship. What happened, lordship? Will find the FIR on page 18, lordship. FIR, this petitioner is not named in the FIR, lordship. Nothing has been recovered as per the FIR in the lordship. That is on page 18, lordship. 2 persons were arrested, recovered from them, lordship. I am the lordship drug distributor. My valid license, lordship, will find on page 20.
Where is the FIR?
FIR on page 18, lordship.
Yes.
Now, lordship, kindly come to the forwarding report on page 19, lordship, bottom part, lordship.
What is your name?
My name is lordship Sajuddin Ahmed Salu. FIR, my name is not there. In page 19, lordship, bottom paragraph, lordship. Here on the statement of the co-accused, lordship, this petitioner was arrested, lordship. 10 numbers of codeine cough syrup, 10 bottles of codeine cough syrup recovered from this petitioner. Lordship thinks is that he is the drug distributor having valid license. Lordship will find that license on page 24 onward, lordship. And even then, lordship, that they said in the ground of arrest, that is on page 20, lordship, the lordship in those cases, lordship has one case, lordship has granted bail, that is on page 35, lordship. And another case, lordship, he has got the anticipatory bail. And he is all the valid drug license and lordship order on page 35 with lordship. Now 10 lordship, 10 bottle lordship, 100 ml lordship, it is 1000 ml lordship. The codeine substance is only 4 mg. And commercial quantity lordship as per schedule. Schedule drugs lordship, schedule serial number 28 lordship. Small quantity is 10 gram and commercial quantity is 1 kg, lordship. If lordship we count the whole lordship 10 bottle of codeine syrup lordship, that will come on 1 kg lordship. If commercial quantity is lordship above 1 kg lordship, that will be considered lordship. If the lordship, the definition of commercial quantity is there lordship.
What is the total weight of the?
That is lordship 10 bottle, 100 ml bottle lordship, 1 liter lordship. And lordship, if we lordship go through the decimal system lordship, that's millicenti deciliter lordship, then 1000 ml will be 1 kg, 1 liter, 1000 ml. If I am not wrong, lordship, subject to correction, lordship. Deci, 10 deci, deci millicenti liter.
No, 1000 ml would be 1 liter. Nobody is disputing that.
Yes, lordship. But it will not come under commercial quantity lordship. And so far, lordship, he is the drug distributor lordship, having all lordship valid license lordship that I have annexed lordship.
Where is the Caesar list? Let us see.
Caesar list is the lordship, that is Caesar. I have not annexed lordship. Case there is there lordship. Lordship will find that Caesar. Sorry, lordship. In the Caesar lordship on page lordship 33 lordship. My part is not lordship there.
Where is your forwarding letter?
My forwarding report, Lordship, will find on page 19, Lordship.
What is the allegation?
Allegation that was,
Let-
Lordship, 10 bottles of codeine syrup recovered from the bedroom of this petitioner, Lordship. In bottom part, Lordship, bottom paragraph, Lordship. During interrogations of the accused person confessed that
Where is the seizure list of this 10
Lordship, that is not only that, but
is
Lordship,
there?
there is.
What is the weight?
1,000 ml total.
Thousand ml equal to 1 liter, Lordship. And here kg, Lordship. Commercial quantity is 1 kg, Lordship. Then 1,000 liter makes it 1 kilogram, Lordship.
1,000 liter does not make it one.
That's why, Lordship. Because, Lordship, only the quantity makes it, Lordship, commercial or, Lordship, intermediate quantity or not, Lordship.
So your submission is that your contraband is less than commercial quantity?
Yes,
First.
first, Lordship, I'm a drug distributor, Lordship. I have a valid license to hold, Lordship, contraband, Lordship, that drugs, Lordship.
Where is your license?
Page, Lordship, 27, the type copy, Lordship, will find on page 21 onwards, Lordship. Twenty-one, 24, Lordship, these are all type copy, Lordship.
Now what it says, you can keep codeine phosphate in your residence also.
Lordship, I'm the drug addict, drug distributor, Lordship. I'm not the, the supplier, Lordship. Drug distributor, Lordship. So I can hold that. I can, sorry, Lordship, I can hold that, Lordship. That permission is there, Lordship. It is not that, Lordship, I'm a peddler, Lordship. Mayor of the statement of the co-accused, Lordship, that Tufan Singh judgment, Lordship, it will not admissible in evidence, Lordship. And Lordship order in the case reference they have made in the forwarding report, that case Lordship is granted, that is on page 35, Lordship. Choigaon PS case number 553/23, Lordship. In forwarding report page 20, it's reflected, Lordship. That case, Lordship, this petitioner got bail, Lordship. Another, Lordship, another, Lordship, anticipated bail was granted, Lordship, in Dhupdara PS 28/23, Lordship.
Yes, Mr. Das.
Firstly, I wanted to state here, Lordship, in his own statement, Lordship, he have stated that these two persons that have earlier arrested, Lordship, heroin has been found with them, but Lordship, he himself stated that he has sold to these two persons and exactly 20 packets, and he has stated, Lordship. Moreover, not only that,
What was the weight of the heroin?
Lordship, here he only stated 20 packets, but the weight is 265 gram.
In FR,
And the recommended is 250.
260 gram in FR. 262
No,
gram,
I'm not-
262 gram.
I'm not accurate, Lordship. I have to say.
262 gram in FR.
It is
62.
No, how he is linked with the heroin which was recovered?
because he himself stated that, Lordship, he has sold to these persons, Lordship, these two persons. And he also deal with this, Lordship. And moreover, in his house, by bedroom, Lordship, this codeine has been found, Lordship.
Now,
1,000, Lordship, ml. It is not, in the statute, it is not stated that excluding 1,000, Lordship. It is not stated. What he is stating, Lordship.
Excluding 1,000 yes.
He is stated that it is 1,000, so it did not come under the commercial quantity.
1,000 ml. 1,000 ml equivalent to 1 gram and 1 liter, Lordship. Not 1 kiloliter, Lordship. And 1 kiloliter is the commercial one, Lordship.
Moreover,
Upper
Lordship,
limit is 1 kilogram.
Moreover, Lordship, here in the section 37, it is clearly stated that, Lordship,
and that he is not likely to commit any offense while on bail.
No,
Likely is their
no,
lordship.
if,
Likely is their lordship.
no, if the,
But he is,
if the.
he is in many other cases,
contraband,
lordship.
if the codeine phosphate,
Lordship,
codeine cough syrup, which was seized in this case,
lordship,
is found to be less than commercial quantity,
lordship,
then 37 is not applicable.
lordship.
Then question of 37 does not arise. We have to decide how much 1000 milliliter is when converted into kg, whether 1000 milliliter is less than 1 kg, because the,
Yes, their lordship, that is in gram and that is in liter lordship,
because in the notification, the weight is given in grams, not in liters.
not in liters.
So you find out.
Lordship. Moreover, one another submission is their lordship. Section 29 is also there. And he himself stated lordship. Heroin, in case of heroin lordship. In case of heroin lordship.
No, his state, apart from his statement and statement of co-accused, what what other material is there on record?
Others, I have not found lordship, but this is that lordship. He is also involved in such cases lordship.
That two case lordship, one has granted bail by this court, another lordship anticipated bail application.
No, this conversion, you give me
Okay,
authentic.
lordship,
Convert 1000 ml into kg.
lordship,
If it comes to 1 kg,
lordship,
or is it less than 1 kg?
lordship,
That query you answer.
lordship,
When will you be answering? When?
Tomorrow lordship.
lordship.
Okay. Heard. Mr. B. Chaudhary, learned counsel for the petitioner. Also heard Mr. K. K. Das, learned additional public prosecutor. Learned counsel for the petitioner sought some time for answering to the query posed by this court with regard to this case. The prayer is allowed. Prayer is allowed. Let this case be listed again on 2nd of April.
Obliged lordship.
Because if you convert liters into kg, may not be exactly equivalent. It may be lesser.
Product is there.
It may be little lesser.
Lordship.
That is my idea.
Lordship.
But you verify it and
Lordship.
clarify it.
Lordship.
Highly obliged.
Item 46 form supplementary is.
Maybe before lordship.
Yes.
My lord, this is my lord charge sheeted matter, my lord, regular bail application, my lord. FIR will find my lord at page 20.
What is the offense?
My lord, it's NDPS section 21C, my lord. Is there, my lord.
Okay.
As per the allegation, my lord, it was alleged that the accused persons was, my lord, in course of Naka checking while the vehicle was coming from Dimapur side toward Bokachan, my lord. That vehicle has been intercepted. And it has, I was the driver of the vehicle which was intercepted, my lord.
Okay.
So, two accused persons, my lord, involved in the present case, and later on, charge sheet was submitted on, my lord, lordship will find Annexure C. It was submitted on 30th of 2023.
Charge sheet is at page?
Page, my lord, page 29, it start, my lord.
Okay.
Relevant portion will be, my lord, page 33 and 34.
What was the contraband?
My lord, it was 363.17 grams heroin, my lord.
363 gram heroin.
Yes, my lord.
From the vehicle which you were driving?
Yes, yes.
Okay. Charge sheet was laid against only one accused.
Two accused person, my lord, it will page 34, my lord.
Who is the co-accused?
Salman Khan, my lord. Page 34.
He is not before us now.
Yes, yes.
Okay. And what is your name?
My name is Sabir Amit, my lord.
Sabir. Okay.
Page 34.
Yes, now what is your submission?
My lord, I have a very limited submission, my lord. On two grounds, my lord. I was arrested on 10/1/2023, my lord. So
why?
today, I will be behind the bar for 446 days, my lord. That is one aspect. And secondly, my lord, charge sheet was filed on 30/4/2023, my lord.
Okay.
So after submission of charge sheet on 30/4/2023, charge was framed on 12/9/2023.
No,
So as on today,
charge sheet was laid on 34/2023.
yes, correct, my lord.
Okay.
So after charge was submitted and charge was framed, my lord, as many as 15 occasions, Learned Court below trial court has, my lord, called for prosecution witness. Witness has been called for on 15 occasions.
Okay.
So no PWs turn up till today, my lord. So, my lord, only limited my humble prayer is, my lord, there is no likelihood that trial will be concluded very early, my lord. So there is apparently, my lord, delay of trial, my lord. I am already, my lord.
Mr. What is your name?
N.K. Muri, my lord.
Mr. Muri.
Yes.
How much delay is sufficient to get bail in case?
Yes, that lordship, I am very obliged to your lordship queries, my lord. I have tried to make an endeavor to find out the lordship queries, but I could not find out any such kind of, my lord, judgment, neither in the provision, my lord. Only, my lord, to that extent, my lord, I would likely to submit, my lord, force addition, rely on force addition, my lord, lordship, my tenure is here, my lord, lordship, it will place on record, my lord, for your lordship satisfaction, my lord.
No, have you got any authority where,
yes,
where the accused having been detained for 446 days was released on bail?
My lord, some suggestion I am relying, but my lord, only thing is, my lord, delay of trial. That will not unfetter the provision of section 37. That is my only limited.
No, but
submission, my lord.
how much delay?
How much delay is not, it is not, my lord. I could not find out how much delay, my lord. But apparently, my lord, 15 occasion court below has fixed a date for evidence, prosecution evidence, but that has not turned up. Shows, my lord, there is delay is causing, my lord.
Mr. Murray, you try to find out a case.
And my lord, likely there are, my lord, 6 PWs.
No.
Where
no, Mr. Listen to me.
Yes, my lord.
Audible. You try to find out a authority which covers your case. You are behind the bar for 446 days. If you can show a case, an authority where the accused charged with an offense of possessing commercial quantity of contraband was released on bail or having been detained for 446 days, then I will consider your prayer.
My lord, question is, my lord, lordship, I appreciate, my lord, but question is whether there is delay of trial or not, my lord, that may be considered.
Okay. Which cases you are relying?
So, my lord, first citation I am relying, my lord, criminal appeal number, my lord, 915 of 2023, my lord. S. Rapindra Phat. Justice Rapindra Phat, Aro Justice Dipankar Datta, my lord. In Muhammad Muslim Ilyas Hussain versus State of NCT. Para 20 and 21, my lord.
Okay, I'll go through it.
Yes, my lord, can may kindly note the paragraph, my lord. And second, my lord, second citation, my lord.
Yes.
Special leave criminal, my lord, 4169, 2023. It was decided on 13/7/2023. Rabi
Para.
Prakash, para 4, my lord. Second citation. And next citation, my lord. It was decided, lordship, this of course may not be binding upon this court, but I just like to impress, my lord, my submission. It was decided by the High Court of Judicature at Bombay, my lord, in bail application 262865, decided on 15 September 2023, my lord. Mara that para 11 and 9. Para 9 and 11 may be relevant, my lord.
Okay.
And my lord, next citation, my lord.
Yes.
My lord, next citation, it was rendered by Honorable Punjab and Haryana High Court, my lord. Khushi Ram versus State of Punjab. It was decided on 3/10/2023, my lord. Very recent judgment.
11 paragraph.
Para 6 may be relevant. Paragraph 6, my lord.
Okay.
So, basing on this submission, my lord, that Honorable Lordship is quite aware, when, my lord, there is a delay of trial, my lord, that section 17 embargo will go, my lord.
Okay. But you are unable to say how much delay.
How much delayed court has not, my lord, I could not, I make an endeavor, my lord, but there was no such judgment, my lord.
Who is for the prosecution side?
I apologize, I have not gone through the case record, lordship.
What is your name, Mr.?
My lord, M.K. Muri, my lord.
M.K. Muri,
Yes, my lord.
learned counsel for the petitioner, also heard Mr. K.K. Das, learned additional public prosecutor.
Arrested on 8.
Let this case be listed for delivery of order on 3rd of April. On 3rd of April, I'll deliver the orders.
1 year, 2 years. No. My lord, just one more thing, my lord.
Yes.
The annexure, my lord, annexure F and G, that was the judgment, my lord, passed by this honorable court, my lord. Coordinate bench of this court, my lord. Annexure F and G.
Okay. Okay, on 3rd, I will pass orders.
Yes, my lord. I'm obliged, my lord.
If you have anything to submit, you may make submission tomorrow or on 3rd also.
Obliged, my lord.
It's unfortunate, my lord. Two brothers, one of the informant, he is also elder brother. My elder brother and I was fighting, and there was an interim order which is passed by this court because it is ultimately a civil dispute. Because a gift deed, it is a gift. A property was gifted, a land was gifted to me by my grandmother. And that is 2007. 2023, after a gap of 26 years, my elder brother comes and lodges an FIR. That gift deed is forged.
Okay.
That then, my lord, there was an interim order which was passed by this honorable court. So I cooperated with the investigating agency and they have recorded my statement.
Okay, whether Kesari.
4 times. 4 times, my lord. So it's my lord.
You have appeared before.
Yes, appear. Yes, appear
Why
documents.
case diary is not there?
No, I have not provided any intimation.
Then we are disposing of this.
Lordship.
There's
We have
nothing-
already, earlier also, we have sent signals, Lordship.
Yes, my lord, it is a civil dispute purely. Kindly see, my lord. It's a gift and all the legal heirs, these all brothers and sisters, these my grandmothers, these sons and daughters, there is no objection. It was gifted by my grandmother. In 2007, I'm residing there. Along with my mother.
This is
along
item
with my
number?
mother.
30.
Heard Mr. D.K. Das,
D. Das. my lord.
sorry, D. Das, learned senior counsel, assisted by Mr.
D. Chakraborty.
D. Chakravarti, learned counsel for the petitioner. Also heard Mr. K.K. Das, learned additional public prosecutor, who submitted that the case diary which was called for has not arrived. He has also submitted that no explanation has been given by the investigating officer for not furnishing the case diary. It appears from record that today is the fourth occasion when the prosecution side was requested to produce the case diary, however, in vain. It also appears from record that by order dated 29/9/2023, the petitioner, Shri Trideep Chaudhary, was allowed to go on interim anticipatory bail by this court with certain conditions. Learned senior counsel for the petitioner has submitted that in pursuant to the directions of this court, the petitioner has appeared before the investigating officer and has cooperated in the investigation. Stops. In view of repeated failure of the prosecution side to produce the case diary, as well as in view of the fact that the petitioner has complied with the directions of this court and has cooperated in investigation, the interim bail granted to the petitioner by order dated 29/9/2023 by this court is hereby made absolute with condition number 1, 2, and 3
Yes.
attached to the said order remaining intact.
But threes will be the not to leave.
Jurisdiction, not to leave the jurisdiction.
That will be, my lord, that's a difficult not to leave. I have some
Daughters are studying.
daughters are studying. That's outside. That's the whole problem now.
No, during investigation.
I'm sorry, man.
Only this embargo is only during investigation.
Right.
If you are required,
If I am required, then that's your lordship will note down. Then I can, my daughter is studying. That's the whole problem. Yeah, outside. Outside, that's all. Where I will leave, how I will fled my, this is my property, I have gifted. Only, that's the only problem, I know your lordship will kindly
condition
note down.
number 1 and 2 remaining intact.
Yes, sir.
With above observation, this,
Moreover, Lordship, we have sent 4 times signals.
Yes,
It may be reflected.
the learned, উপরত দেখিব, learned additional public prosecutor has submitted that the office of the public prosecutor has sent requisition and reminders on 4 occasions to the investigating officers. However, said has not been replied to by the investigating officer. With উপরত থাকিব, with above observation, this anticipatory bail application is disclosed.
Strictly on this.
Please, madam. Because item 31 to 34, madam, they relate to the same FIR, the co-accused persons.
Kindly pass out the matter for the time being, Lordship.
31 to 34.
Yes.
Kindly pass out the matter for the time being, because this has been looked down by Lordship, APP, RJ Borua.
Borua. Let Borua come.
CD is not here. though.
CD is not there.
No, no.
CD is there, Lordship.
CD. So isn't it CD?
Okay.
You are on interim bail.
Yes. madam.
You are on interim. bail.
Yes.
Let him come. Mr. Borua come.
Yeah.
May I please your lordship? 430 application, your lordship.
LCM. My lord, in the last occasion, LCM was called for, my lord.
Section
But
4.
regarding the service, my lord, let me kindly peruse the office note dated 28/3, my lord. 24, my lord.
What will we do?
You will have to take first step, my lord, for officer insertion.
Earlier it was sent through registered post.
Please,
Ah.
post lordship.
Registered post.
Lordship.
You send it through the officer in charge of take fresh steps.
Lordship.
Heard Miss G. Bora, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. Whether scan copy has
I
arrived?
receive, my lord.
Stop. It appears from the office note dated 28/3/2024 that neither AD card nor service report as regards the notices issued on respondent number 2 has been received. It also appears that the notices were sent through registered post with AD. However, the mode to send the notices to the victim slash guardian of the victim slash support person of the victim has been prescribed by a division bench of this court in the case of Deepak Nayak versus State of Assam. And said mode has not been followed in this case. Therefore, the petitioner is directed to take steps again for issuance of notice on respondent number 2. The petitioner shall submit the written up notices along with the copy of bail application with all annexures to the registry, which in turn shall forward it to forward the same to the learned public prosecutor, who shall forward the same to the officer in charge of jurisdictional police station, that is Sutia Police Station. Stop. On receipt of the said notice, the officer in charge of Sutia Police Station shall serve the notice on the respondent number 2 and submit a service report to this court through learned additional public prosecutor before the next date fixed. The petitioner shall take steps within 2 days from the date of this order. Let the case be listed again on
After view, my lord, 19th, my lord.
on 19/4.
Item 47.
Yeah, 438 application, your lordship. The allegation is 341, 325, 294, and added section, your lordship. 326 also there. But my lord, to main actual fact of the case is that, your lordship, kindly come on page number 4, your lordship, paragraph 8. My lord.
Case diary is there.
Petitioner's PD field and the informant's PD fields are adjacent, your lordship. And informant number, informants and petitioner number 2 are lordship cousin brothers, your lordship. So, my lord, there have been dispute between the two parties regarding the demarcation of their land, your lordship. So, my lord, in this regard, the petitioners were also beaten by the informant and his son. And to this effect, the petitioner number 2 has been also filed an FIR on the same day, your lordship, where the same Samuguri police station had case number 30/24, my lordship. And their police case number is 29 and our is 30, your lordship. This is the main allegation, your lordship.
What injury you suffered?
My lord, medical report was called for, your lordship.
So the medical report is there. It is grievous injury, lordship, on head. And victim statement is also there. Injured statement is there. He also implicated this person, lordship.
No, but my lord, our cases also call for, your lordship. Case number 30.
Case number 30, we have not found it.
earlier, case number 30 and 29 are also.
In case number 29, it is grievous.
But my lord, we are our family, so we are only paid earner, your lordship. So my lord,
No, but this does not appear to be a case of anticipatory bail. What was the injury?
Injury is grievous, Lordship.
What is the description?
Lordship. In the heavy sharp Lordship. And cut injury is there on head, laceration of size 4x3. Lordship may look into it.
Heard Mr. P. Rahman.
I am S. Islam, my lord.
S.
S. Islam.
S. Islam, learned counsel for the petitioner. Also heard Mr. K. K. Das, learned additional public prosecutor. This application under section 438 of the Code of Criminal Procedure, 1973, has been filed by the petitioners Ahmad Ali and Masarab Ali, who are apprehending their arrest in connection with Samaguri PS case number 29/2024 under section 341/325/294/34 of the Indian Penal Code. 34 and section 326 of the Indian Penal Code. The gist of accusation in this case is that on 30/1/2023, one Muhammad Iman Ali had lodged an FIR before the in charge of Moyamari Police Outpost, inter alia, alleging that on 30/1/2024 at about 9:30 AM, when the son of the first informant went near the accused persons named in the FIR, including the present petitioners, they assaulted him with spade and caused grievous injuries on his person. Learned counsel for the petitioner has submitted that there was a land dispute between the present petitioners and the family members of the first informant. And due to the said dispute, on the date of alleged incident, altercation took place between both the parties, and the petitioners were also beaten up by the other side. Where is your FIR?
Oh, that's not like this FIR.
You have not any.
No.
Stop. Learned counsel. Now, what is your submission?
Madam, my submission is that no, so we have also crossed FIR on the same day and same down, say lordship. We are also beaten by them. So we may be allowed to go on bail and maybe we will appear the IOL lordship as soon as possible.
Learned counsel for the petitioner has submitted that the petitioner would cooperate, petitioners shall cooperate in the investigation, and on that ground, they have prayed for allowing them to go on anticipatory bail. On the other hand, learned additional public prosecutor has produced the case diary of Samoguri PS case number 29/2024 and has submitted that there are incriminating materials against the present petitioners and has vehemently opposed the grant of anticipatory bail to the present petitioner. He has also pointed out that the injury report of the victim, which is available in the case diary, shows that the victim has suffered grievous injuries on his head, including fracture on frontal region of the forehead. Stop. I have considered the submissions made by learned counsel for the parties and have perused the materials available on record, including the case diary of Samoguri PS case number 29/2024. Stop. On perusal of the case diary, it appears that the victim has suffered grievous injuries on his person, on the vital part of the body, including fracture on frontal region of the forehead. It also appears that there are other evidence which incriminates against the present petitioner. What is your name? Marhab.
Arhad, Ahmed Ali, and Ahmed Ali and Masrab Ali. Yes, madam, Masrab Ali.
The
Accused number 1 and accused number 2.
the statement of the injured victim recorded under section 161 of the Code of Criminal Procedure also implicates both the present petitioner. Therefore, this court is of considered opinion that this is not a fit case where favorable orders may be passed under section 438 of the Code of Criminal Procedure in favor of the present petitioners. The prayer for anticipatory bail is accordingly rejected. Send back the case diary.
May it please your lordship, the 438 application, my lord, the FIR is at page 11. And this FIR has been lost, my lord, near about 40 days after the incident, my lord. And totally false statement has been made in the present FIR. And they have stated in the FIR that the
No,
delay,
whether the notices are served on
my lord.
respondent number 2.
Yes, my lord, the as per office note, my lord, I have seen, my lord.
You are
Someone
appearing
has
for.
already appeared.
Okay. Yes.
Someone has appeared. my lord. So, as per their statement in the FIR, my lord, these
Where is the FIR?
FIR is at page 11, my lord, and the vernacular is at page 14, my lord. The FIR lodged on 8/11/2023, and the incident was on 30/9/2023.
How much delay?
My lord, delay near about 40 days, my lord. And the explanation for such delay, they have stated that due to village visa. In fact, my lord, there was a
Due to?
village visa.
Due to
Village visa.
valid visa.
Village village.
Oh, village.
Village visa.
Acha. Okay.
In fact, there was a village visa, my lord. But the story in the village visa and the story in the FIR totally different, my lord. But this village visa, I have, my lord, annexed is at page 15.
No, what was the allegation? What is the allegation against you?
My allegation against the petitioner is that the petitioner has done some unnecessary offences with the minor son of the informant. That is the basic allegation.
Okay.
But story is totally different. Well, kindly see the Belize Bizarre. I have annexed at page 15. Well.
What is the story there?
Yes, page 15. Well. The story is that well, the minor son of the informant was stolen a 500 rupees in absence of the petitioner from his house. Well. And in the evening, when the petitioner returned back and found that his 500 rupees is missing, then on query, my lord, the family members told him that the so-and-so person was entered into his house at the afternoon. And thereafter, he called the said minor and asked him, and then he confessed that he has taken the rupees 500. At that point of time, my lord, the informant came to the house of the petitioner, and then they agreed for the Belize Bizarre, and accordingly a Belize Bizarre was held. In that Bizarre, the 500 rupees has returned back by the informant, and after 40 days, this FIR has been made. If, my lord, assuming if such type of heinous crime has been committed at that point of time, so question of Belize Bizarre does not arise at all. Immediately they ought to have been lodged the FIR. Totally manufactured and afterthought, my lord, only to harass the petitioner. And in the FIR, my lord, they have said this, someone has video recording the incident. I don't know, my lord, what the records reveals, whether there is any video recording is there or not. That will reveals from the city itself. And the medical report, if such type of heinous crime has been committed, my lord, the medical report definitely shows something. My lord.
After 40 days, it will not show anything.
But my lord, the delay part, 40 days delay for such heinous crime.
So you are,
That cannot be acceptable.
mainly your submission is delay. And-
Mainly delay, and there is no such offense has been
And
committed
this
by
is
the petitioner.
concocted. story.
Concocted story, and story is otherwise else. That is I have stated, that is I have annexed in the page 15. Man. That is the Belize Bizarre. Wherein the page 15 man, of my petition, when clearly stated the entire facts. Man.
Why false allegation was leveled against you?
Well, because he caught the minor son of the informant, and the 500 rupees is supposed to he return back.
Yes, Mr. Das.
164 statement is there, Lordship, of the 15.
Videography is there.
Videography is there, Lordship, but they have deleted it because the elder person stated that, but the mobile has been seized, my Lordship, and it has been sent for recovery of the data, Lordship.
Deleted video.
Deleted the video. And moreover, Lordship, one witness name is also there, Sahihul Paramani, Lordship, in the FIR. His statement is also there, Lordship, that he has recorded. And may look into the city.
You have any submission?
Upon a 10-year-old minor boy, and there is I witnessed that incident. That's all.
No, yes, Mr. Das. Now, what is your submission?
Well, at this stage, Lordship, investigation is going on. Moreover, 164 statement, 161 statement, more or less similar, Lordship.
Contradictions are not there, Lordship. Moreover, eyewitness is also there, Lordship. Though the video recording may not be there, Lordship, but he is the eyewitness, Lordship.
But in
This-
fact, my lord,
but
I
it
have stated in my petition, the eyewitness whose name my learned friend has taken, he stated in the Bichar, I have stated in my petition that I have not recorded any such video like that. But I don't know what is what. But it seems the video recording is not there. Medical report is not there. In fact, my lord, in some cases we have seen, like the 498, now the POXO Act is also misusing, my lord. So many cases we have seen, my lord. Otherwise, my lord, my simple submission, if such type of heinous crime has happened on that day, after 40 days, we will wait for that. Question of village bishop does not arise at all for such type of crimes, my lord. Others assaulting, that's altogether different thing. And the 161, 164, whatever may be, that is the concocted. And as per my information, this minor boy, my lord, he is victim of the consuming branded. That's why he's searching for rupees whenever he get the chance, he's taken by stolen the rupees from someone else. That is the real fact. And the up to your lordship, after very jaldi.
Heard. Materials are there. Heard. Mr.
R. Islam.
R. Islam, learned counsel for the petitioner. Also heard Mr. K. K. Das, learned additional public prosecutor, as well as Mr. H. Rahman, learned counsel for the informant. This application under section 438 of the Code of Criminal Procedure, 1973, has been filed by the petitioner Aminul Islam, alias Aminul Sheikh, who is apprehending his arrest in connection with Sukchar PS case number 260/2023 under section 342/328/377/506 of the Indian Penal Code, read with section 4 of the POXO Act, 2012. The accusation in this case is that the informant, who is the mother of the victim boy, had lodged an FIR on 8/11/2023 before the officer in charge of Sukchar Police Station, inter alia, alleging that on 30/9/2023 at about 4:30 p.m. the present petitioner took this minor son of the informant to his house, and by administrating addictive tablets committed unnatural sex with the minor son of the informant. Stop. Learned counsel for the petitioner has submitted that the allegations leveled against the present petitioner in the FIR are not true. It is also submitted that it is also submitted by learned counsel for the petitioner that the FIR has been lodged after 40 days of the alleged incident, and the only explanation given for delay in lodging the FIR is that a village meeting was held in respect of the said incident. Stop. Learned counsel for the petitioner has also submitted that the village meeting was not in fact connected with the allegations leveled in the FIR, as the said meeting was held regarding the allegation of theft of 500 by the minor son of the informant from the
house of the
house of the present petitioner. On the other hand, learned additional public prosecutor as well as learned counsel for the informant vehemently opposed the grant of anticipatory bail to the present petitioner on the ground that though one of the witnesses whose statement is recorded under section 161 of the Code of Criminal Procedure has stated that he made video recording of the alleged offense. However, and later on deleted the said video recording from his mobile phone. However, the endeavor of investigating officer to retract the said video recording is on, and the said mobile phone has been sent to forensic laboratory for the said purpose. It is also submitted that the witness who made the video recording, who allegedly made the video recording of the incident, had in his statement under section 161 of the Code of Criminal Procedure has implicated the present petitioner. I have considered the submissions made by learned counsel for both the sides and have perused the materials available on record, including the case diary of Sukhchar PS case number 260/2023. Though in this case there is a delay of 40 days in lodging the FIR. However, considering the nature of allegations made against the present petitioner, as well as considering the materials available in the case diary, including the statement of the victim, as well as statement of the witness who had seen the alleged commission of alleged offense, this court is not inclined to grant the benefit of anticipatory bail to the petitioner in this case. Accordingly, the prayer for anticipatory bail in this case is hereby rejected. Send back the case diary.
Much obliged.
My lord, we are waiting for item number 13, lordship, since morning, lordship.
I am also waiting.
Other also there, 16 and one matter LCB 17. But lordship, we personally made him and made a request to come to this court. He said that lordship, after completion of this item number in the court number 10, then he will come, lordship. But after that, lordship, just coming, he said that just coming, thereafter he had not come, lordship.
Lordship,
So
that
that
matter was still
should
going
not
on,
be
lordship.
excuses, lordship. This court, he is
The
avoiding.
problem is NCB has only one standing counsel.
So lordship may pass a direction to appear this personal appearance for this zonal director also before this.
To appoint more standing counsels.
Lordship, that is required right now because lots of matters, he is appearing in lots of
You
matters.
can take instructions
Lordship, my senior will come after.
because
some time,
there
lordship.
their ground is mainly on prolonged incarceration or some other grounds are also there. What is the ground?
That is the main ground, Lordship, because in my case, he is inside for about.
This interlocutory application. This is for bail, suspension of sentence.
Yes.
Heard Miss N. Hassan. Miss N. Hassan,
And Hassan.
learned legal aid counsel, appearing for the applicant. Also heard Mr. K. Das, who has submitted that the opposite part respondent, state respondent has submitted written objection today only. It appears that the written objection filed by the opposite party has not yet been placed on record. Let the registry tag the written objection filed by the opposite party along with the record and list this case. When should I list it? When? After 1 week.
One.
After Bihu, Lordship.
After being.
After 2 weeks.
Next.
Item 39.
May I please, Your Lordship. Here, Lordship, this interlocutory application has come up for consideration of his prayer for bail and suspension of sentence. Lordship. Yeah, he is in custody since the date of judgment, Lordship, that is 30/6/2023. And he is convicted for 7 years. Records are here, Lordship. And here prosecution case was that, Lordship, the informant who is the victim, Lordship, she lost the case alleging that there was an affair with the present petitioner, Lordship. And due to, Lordship, that they had some physical relation and she became pregnant, Lordship. And thereafter she was, Lordship, medically examined and medical exam.
May I please, Your Lordship, my lord? Here in the instant case, my lord, this petitioner was, my lord, convicted under section 21C, my lord, of NDPSS, my lord. And my lord, he was, my lord, arrested on, my lord, 28 September 2021. Now he is behind the bar for, my lord, 2 years, 6 months, 9 days, my lord. And my lord, prima facie, my lord, there is I saw Your Lordship, my lord, the bail application, they argue on bail application, my lord. I saw Your Lordship that 52A to C was not complied of, my lord. On the face of the record, my lord. And it was
52?
A to C, my lord. Where Mohanlal has said if 52A to C is not complied, my lord, he is entitled for, my lord, bail also, my lord. Acquittal and bail also, my lord. Your Lordship, kindly come to the 52A to C, my lord.
No, before that. Who is appearing for the?
My lord.
Today, we are taking up only the interlocutory application.
Yes, my lord. They have filed also objection, my lord.
They have filed objection.
Yes, my lord.
Okay. But no order has been passed in interlocutory application.
What's it do? Yes, my lord. It was filed on, what's it, 9 November 2023.
Okay.
And my lord, India, my lord, objection, para 5, they have stated.
No,
my lord.
what is your? No, this is perhaps not the case.
Munirul Zaman.
Yes, Monirul Jaman.
Only.
The objection was filed on 9th.
Objection was filed on my lord. They filed an objection on my lord 9/11/2020. This is the copy
The I.
in the IA. IA number is my lord 1021 of 2023.
That is I. Itu ayat থাকিব।
Paragraph 4, Roman 3, page 5.
Putul, this is the objection. Okay,
Your lordship kindly come their objection, my lord.
yes.
Paragraph 4, Roman 3, my lord.
Paragraph,
Paragraph 4, Roman 3, page 5, my lord. Only, my lord, 13 bottle cough syrup has been, my lord, recovered from the courtyard, my lord, of the, my lord, accused person house, and he was convicted for, my lord, under 21C. And they,
what was the quantum of punishment? How, for how?
10 years, my lord.
10 years.
Yes, my lord.
RI for 10 years, fine of 1.
Fine of 1 lakhs, my lord.
Okay,
And, my lord, there are 4 persons inside the house, my lord. That was also proof, my lord. Witness says we do not know, seizure witness says we do not know what has been seized. PW1 says, he has said, I am only the person. PW2 said there are 2 persons. And it was recovered from the courtyard, my lord. And most important thing is that 52 A2 2C was not complied with. They were admitted. I am read my para 5. PWC, the investigating officer, may I read my lord?
which para?
Para, my lord, Roman 3, page 5.
Yes, yes.
PWC seeks the investigating officer on 28/9/2021 entrusted with the investigation of the case. During his investigation, he recorded the statement of the informant and recorded the statement of the village headman Anwar Hussain, the eyewitness of the incident. On 29/9/2021, he produced his article before the learned judicial magistrate Morigaon as per 52A of the NDPS Act. He also placed prayer for drawing sample and photograph of the article. He also prayed for certification of correctness of the inventory. After drawing the sample, he sent the FSL to SFS Morigaon.
These
He
samples was never certified.
list of sample that was, my lord, never certified by them, which is important, my lord. Your lordship kindly come to the 52A.
No, no, under 52A,
Yes, my lord.
inventory has to be certified.
Yes, my lord.
Progress was
Photograph also certified. Your lordship kindly come to this, my lord. Ase na? Page 41 also. Okay, page 41, my lord. That 52A 2C, my lord. I am reading A also, my lord. What is 2A, my lord? In any proceeding or any application to any magistrate for the purpose certifying the correctness of the inventory note so prepared, taking presence of such magistrate photograph and certifying such photograph, this too is available. C, allowing to draw representative samples of drug or substance in presence of such magistrate and certifying the correctness of any list samples so done. That was not done, my lord. It is apparent from the, my lord, record also, my lord. If you also record, my lord, page 2, overly, magistrate has said, my lord.
Where?
Page 2 of the record, my lord. Para 4, overleaf, my lord.
Which
Ulai diasun, record.
LCR
to দেখছো
LCR page 2.
ulai দেখো ulai এই যে পেজ মার্ক লাগাই
You need it.
Yes, we'll just flag it.
Yeah.
Oh. Oh. Pencil line, no? Not here,
Green or red, blue line.
Green to 2 number page, no?
Plastic.
Page 2, my lord. Para 4. With regard to the narcotic drugs and psychotropic substances fight, MR number 101/2020. Have you also got it?
Yes.
Then the concerned IO has further paid under section 52A NDPS Act for C. A1, I am script over C, my lord. Allowing draw representable sample in presence and to certify the correctness of the list of samples so drawn. Then your lordship come to the page 3.
Page 3 open.
Overleaf, my lord. Blue flag, my lord. Error 3. Further for sampling of C's article 1. Have you also got it? 1 ml, 100 ml bottle out of 13 liters cough syrup is taken so sample and kept in a sealed condition in presence. The rest of the 12 bottles are also kept in sealed condition in my presence. Hence, I hereby certify the correctness of sample. Let the original certificate of inventory and certificate of the photograph seized substances along with the 2 certificates be kept with the record. Third certificate is not available, my lord.
Directly on. Because of original discourse.
And next, my lord, let the representative sample along with the remaining seized article, photocopy certified inventory and certified photograph of the seized substance along with the photocopy 2 certificates.
Your submission is that the certificate which is mentioned in 52A to C has not been given.
Not, my lord.
But the order sheet shows that said certificate was certified.
The sample was certified, not the list of samples.
Sample was certified, not the list of sample. That is why I am again reading, my lord. See, last part, my lord. Certifying the correctness of any list of samples so done. Last line, my lord. 52A to C. This is one of the point, my lord. Following the Mohanlal, my lord.
There are 12, 13, 14.
No, Tagmaras. Your lordship kindly come to the para 12, 13 and 14, my lord. There are other point also, my lord, in this. Only from 1 bottle sample has been taken. They have not taken sample from each bottle, my lord. That is another point, my lord. They have sent in the forensic laboratory only 1 bottle. Other bottle were not. And when the cross-examined the IO, he said, and my lord, the FSL expert also said, he does not know the batch number. If the batch number was not telling, my lord, then how can, my lord, they said, my lord, all are my lord, psychotropic substances available, my lord. And one more important thing is that some expired drugs was recovered, my lord, from his house, my lord. That is also not mentioned, my lord. Maybe that is other bottle also, my lord. Maybe other things may be there, my lord. I am coming on that judgment, my lord. These are not. Para 12, 13 and 14, my lord.
13, line number 6, no evidence.
Para 12, my lord. Have you also got it, my lord?
Yes.
Judgment, my lord. That judgment, my lord. Yusuf, my lord. Para 12.
Yes.
A simple reading of the aforesaid provision also stated there earlier revealed that when any contraband is and forwarded to the police officer so mentioned under section 53. The referred to subsection 1 shall prepare inventory, detail of description of substance, like quantity, mode of packing, numbering, identifying mark, then make an application to the magistrate for the purpose of certifying the correctness for allowing the represented sample substance in presence of magistrate, and to certify the correctness of the list of samples so done. Then next paragraph. Last line, my lord. The man to certify the correctness list of samples so done. 13.
In this case, no separate list was prepared.
No, my lord.
List was not prepared.
Not prepared, my lord.
Because list was not required.
Yes, sir. Is it?
Only one bottle was sent as sample.
Which also is illegal.
This is also.
But is it necessary that list has to be prepared?
As per decision of the apex, my lord, it is mandatory. That was not prepared. They have admitted in para 6 also, affidavit, my lord. And my lord, from the record I have shown, my lord, only 2 certificate is available. 3rd certificate is not available, my lord.
No, he has certified it to be correct in the order sheet.
Sample is certified.
Sample has been certified, my list was not certified, my lord. That is why I am hammering on this word, my lord.
List was certified.
Yes, my lord. Yes, my lord. Para 13, my lord. Notwithstanding the defense set up from the side of respondent, instead can no evidence has been brought on record to the effect that procedure prescribed subsection 2 and 3. That is important, my lord. 4. Section 52 was followed while making the seizure and drawing samples, such as preparing and the inventory and getting it certified by evidence. No evidence has also been brought on the record that samples were drawn in the presence of magistrate and the list of samples so drawn was certified by the magistrate. The mere fact that such samples were drawn in presence of gazetteer is not sufficient. Next paragraph, my lord. It is an admitted position of record. Samples from the seized substance were drawn by the police in presence of the gazetteer, not in the presence of magistrate. There is no material record to prove that magistrate had certified the inventory, substance, seizure, or the list of samples so drawn, my lord. Accordingly, in Mohanlal case, the apex clause while dealing with the 52 clearly laid down that it is manifest from the provision upon seizure, contraband is has been forwarded either to the officer in charge to the nearest police station or to the officer employed under section 53 who is obliged to prepare an inventory, seize contraband, then to make an application registered for the purpose of getting correctness certified. It has been further laid down the sample done in presence of magistrate. List thereof of the certified alone would constitute primarily evidence for the purpose of the trial.
This can be tried. Without the list, there is no sample, there is no drugs in the trial.
Without the list, my lord, it is mandatory, my lord. How can they say it, my lord? And another thing is that, my lord, in this case, important case, my lord, it was seized on
28th September 2021.
At 2:30 AM, 28th September
2021.
2021 at 2 AM, my lord, that they, as per ocular evidence, drugs has been seized. As per seizure list, it was seized
In the morning, 28th, before 3:45.
and 28 in the evening at 3:45, the goods were seized, my lord.
No,
And
when it was seized?
it was, as per say ocular evidence, it was seized on, my lord, 28th September 2021 at about 2:33 AM, my lord, seized, my lord. I shall go to the ocular evidence. Yes, my lord. Then your lordship, as per seizure list, as per seizure list, if your lordship go, they said that it was seized on 2:30 to 3 PM, my lord. It was seized. I am not on that, my lord. They said, my lord, on 28, MR has been, number has been given, MR number 101, 2021. And it was shown before the magistrate, my lord, on, my lord, 29. How can MR number has come, my lord? Before, my lord, it was seen before the magistrate, my lord. That is the second point. My third point is they have.
What is your second point?
My second point is that, my lord, as per my lord, ocular evidence, it was seized on 28 9/2021 at 2:30 or 3 AM, my lord. AM, my lord. In the morning. As per seizure list, if your lordship go, my lord, then date of seizure is 28/9/2021 at 3:45 PM, my lord. More than 12 hours, my lord. And it was, my lord, seen before the magistrate on 29. 29/9/2020, it was seen before the magistrate, my lord. And my lord, they have MR number has been put on 28/9/2021. 28/9/2021 is the, my lord, Tuesday. Without producing before the court, my lord, how can MR number has come, my lord? That is.
No, after seizure of the contraband,
Yes, my lord.
it will be produced before the officer in charge of the police station,
Yes, my lord.
who will produce it before the magistrate.
Yes, my lord.
When it is produced before officer in charge of police station,
Yes, my lord.
he may give a season.
As per police manual, my lord. The answer no, 67, I guess.
Under 57,
Yes, my lord.
Part 4.
Rule 63. And another thing is, my lord, they have to produce the Malkhana register, my lord. Malkhana register was not produced. From, my lord, morning it was seized, my lord.
no, no.
To next day, seen.
In this
Yes, my lord.
interlocutory application,
Yes, my lord.
we will not go very deep into the evidence.
Yes, my lord.
If apparently you are able to show
Yes, sir.
that there was a violation of mandatory provision,
Yes, 52A to
which
3.
you are
That is
mentioning
52A
that
to 3.
52A,
2-3, my lord.
They've admitted that they've not.
They have admitted, my lord, in the objection.
that whether a list of samples is to be drawn.
All right, sir. Is this the mandatory provision they have violated, my lord? And if your lordship go to the evidence, my lord, search seizure witness has said, we do not know what goods has been, psychotropic substance has been seized. I can read all this evidence also, my lord. Very good, my lord. In Mohanlal case, paragraph 17 to 19, my lord.
Mohanlal is there.
I am not reading, I am so your lordship. 17, 19 and 21, my lord. 31.1.
Yes, Mr. Sharma. Or Borua, who is appearing? No, there, in this interlocutory application, we will not go into all aspects of all discrepancies. If they are able to show that there is a violation of mandatory provisions, only then they will be entitled to get suspension of sentence and bail during pendency. Their submission is that under 52A plus 2, 4, 3,
C, my lord. C.
C, the requirement is of certifying a list of samples. However, in this case, no list of samples was drawn up, and therefore no certification was there of list of samples. That is your submission.
Yes, my lord.
My humble submission, Lordship, this is the main point, Lordship, which he has asked, my lord. So let the main appeal may be heard, Lordship. We will also prepare it because today it has come for orders, Lordship. Only Lordship, from the PW6, evidence of PW6, Lordship will find it, my lord. No, yes, also this one.
No, prima
I am
facie.
referring from the judgment, Lordship. Because my lord,
If prima facie they are able to show during, in the, under what circumstances in an NDPS case, during the pendency of an appeal involving commercial quantity of contraband, the suspension of sentence may be granted.
my humble submission, sentence cannot be suspended because
Under no circumstances.
under no circumstances, that is, my lord, it is clear from the, my lord. My lord, 1999 3 SCC 321, Lordship. Mokbul Singh versus State of Punjab, my lord. No sentence awarded under this act shall be suspended or omitted or commuted, my lord. 1999 3 SCC 321, my lord. 99 3 SCC
1990,
99, Lordship.
3
Nine-
SCC,
Page 321.
no, just a minute. What it says?
My lord, I am only, my lord, written down the, my lord, citation, Lordship. No sentence awarded under the act shall be suspended or remitted or commuted, my lord, during pendency of the appeal, my lord.
My lord, that bar was not on the statute also, well, how can they cite that? Blanket order, well, one line. There is no absolute bar.
No, there is a provision in NDPS Act also, section 32A,
Yes, my lord.
which bars suspension of sentence.
Section 32A.
Yes, but that was held to be unconstitutional.
Yes, my lord. Lordship, 32A of the NDPS Act, my lord.
What it says?
I'm reading, my lord. No, notwithstanding anything contained of the Code of Criminal or any other law for time being order, but subject to provision, but subject to section 3, no sentence awarded under this shall be suspended or remitted, committed. There is no vice of unconstitutional 22 insofar as it take away the power the executive confer upon it. Section
No,
4.
that has been held to be unconstitutional.
Yes, my lord. I'm-
32A, which puts a absolute embargo in suspending the sentence, has been held to be unconstitutional in Dadu, Tulsidas versus
Yes, that
State of
is
Maharashtra.
2008 SCC 437.
Yes, 2008 SCC 433.
437.
So if they are able to show that,
No sentence,
that here also embargo of section 37 is applicable in a application under 389 also.
Yes, sir.
If it involves commercial quantity.
Commercial quantity.
But if they are able to show that mandatory provision of NDPS Act
It's fine.
was not followed, then they may get suspension of
My lord.
sentence. That is my understanding.
My lord.
Now, what is your submission?
My humble submission, Lordship, that the matter may be hard, Lordship, because we have not gone to the scanned copy today, Lordship.
No, we are hearing the interlocutory application.
My lord.
We have to,
Regarding Lordship 52A notice, my lord, Lordship may peruse, my lord, page 27 of the, my lord, judgment. Memo of appeal, Lordship. Page 27.
no, in the record, it appears that sample drawn was certified.
Yes.
But their plea is that list of samples was not prepared in this case.
My lord, my humble submission, Lordship, the list of sample is not required, but only the sample to be certified, Lordship. Because my lord, only from the bottle of one bottle, Lordship, this substance has to be
No,
sent
they
to the
have
official
shown-
report, my
They
lord.
have shown,
My lord, page 27, Lordship, may
no, you reply to the observation made in Yusuf's case, where it is stated that that in para 13, that list of samples so drawn were certified by magistrate. That is a you answered this query.
My lord.
Let him answer.
Yes, ma'am.
We are keeping it part heard. Let
Yes,
him
ma'am.
answer tomorrow, day after
Yes,
tomorrow.
ma'am.
Day after tomorrow also.
Yes, ma'am.
Your submission is over. Your submission is only with regard of not certifying the list of samples. Main
Another-
submissions, other submissions that the Caesar was,
Caesar would have not supported the case, my lord.
yes,
Caesar would
those matters we will not go into in.
And another thing is, my lord, they have to collect the sample from each bottle as per rule, my lord.
No, that is not required, lordship. Not from the end, all the bottle, lordship. Suppose tomorrow one truck of lordship cough syrup recovered in
Yes,
this.
on
He will
that-
send out the entire truck to the FSL over.
Now,
It is not
this is the
required.
rules, my lord, new rule, my lord, under 2022 rule, my lord. I am not submitting anything from my.
Subject to correction, lordship.
So where is that rule?
Yes, my lord. Let us see.
What it says?
Yes, my lord. Your lordship kindly come to the rule 22 আছিল ন? পুষ্পাঞ্জলি মুক্তি দিলাম দেখানো পাবো। Yes, my lord. Chapter, my lord. Sampling. 10, my lord. Rule 10. Page 10, my lord. Drawing of sample. Have the lordship got it?
Chapter?
Chapter 3, sampling. Drawing of sample. Drawing the sample.
Yes.
One sample. 10-1. Drawing sample. One sample in duplicate shall be drawn from each package or container seized. When the package and container seized together are identical seized, where identical marking and content of each packet give identical result of color test by drug identification kit conclusively indicating the packets are identical in all respect. The packets are going to make carefully bunch a lot of and not more than 10 packets container for each lot of packets container one sample. Provided that in case of ganja, so that is not important. In case of drawing sample for a particular lot, it shall be ensured representative sample equality is taken from each packet container mixed together to make a composite whole from which sample are done and for that lot, my lord. My humble submission before your lordship is that, my lord, when it was interrogated to the scientific officer, he said there is no batch number. I don't know batch number. Police also said no batch number. If the batch number is the same, then my learned friend was said that may be correct. Then how can they say all these things, my lord, from one bottle? And there are other expiry drug is also available along with this, my lord. It is not that he is the businessman, my lord. He has taken some from the farmer, some medicine has been taken, my lord. This is the case, my lord.
Okay, let him.
And that is why, my lord, list is necessary, my lord. Otherwise, how can say, my lord, this bottle has been sent, this bottle was not sent. That is why list is not. That is why, my lord, Honorable Appeals Court has 52A to C has been inserted.
Okay, let us see.
Yes, ma'am.
You reply day after tomorrow.
My lord.
Heard Mr. NND Chaudhary, learned counsel for the petitioner. In interlocutor application. Also had Mr. Though the hearing on the interlocutory application by the learned counsel for the petitioner is concluded, however, learned additional public prosecutor sought some time to reply to the submissions made by learned counsel for the petitioner. The prayer is allowed. Let this matter be listed again on 3rd of April 2024
Matter will be remain priority.
as part of matter.
That's right.
একটু ইয়াত স্টেপল করি
Item number 31.
That's 31 to 34 may be taken up together. Same FIR. That's pursuant to the interim order which was passed by this honorable court on 28th of February. The petitioners before your lordship had appeared before the police station with us. These are the receiving which has been provided with us by the OC of the police station. On 1st of March, they appeared with us, and then on 15th of March, they appeared again in the police station. And they have been interrogated for an hour each on 15th of March. Now, that's my humble submission in relation to the offences. There are 3 non-bailable offences.
Now let us take one by one.
Yes, Milord.
31,
Yes.
item number 31. All the matters are,
From the same FIR, Milord, the co-accused people in the same FIR.
okay. You will
Milord,
make
can-
your submission in respect of item number 31.
31, yes, very well. Page 24, Milord, is the FIR.
No, what is your submission? You have appeared before the IO,
Yes, we have appeared.
have
Now-
cooperated.
Yes, we have cooperated, Milord, on 2 dates, Milord, 1st of March and 15th of March. That is 1, Milord. Number 2, Milord, there are 3 non-bailable offences under section 353, 332 and 365 in the instant FIR. 365 has been added later, Milord. It's not there originally in the FIR. My humble submission, Milords, is that none of these offences are made out on a prima facie reading of the FIR. Which brings me, Milords, again to page 24, which is the FIR. This is the vernacular. If I may read, Milords, the FIR.
No, before you make your submission.
Yes.
Mr. Barua,
Madam,
what is your submission?
my humble submission is there are some eyewitnesses, Lordship, who have shown, Malad, so that Malad, the victim, Lordship, he was taken from his office to the ASUS office, then he was confined, then he was assaulted, Lordship.
No, now do you need their custodial interrogation?
That I leave it to your Lordship because.
Because
Lordship,
they have appeared before
they
the
have
IO.
appeared at their statement recorded, although my lord, in their statement, they have denied, Lordship, that they, my lord, forcefully took the victim to the ASUS office, then he was assaulted, Lordship. And regarding, Lordship, my lord, the injury report, Lordship, which is simple, caused by blunt weapon, blind force.
That's also point. There's a cross FIR also. Because it's only natural that I'll deny it because I've also given my version of.
No, if he denies, there may be other witnesses, other. You
Witnesses, my
continue
lord,
your,
witnesses said, Lordship, my lord, witnesses, my lord, other person who accompanied the, my lord, victim, Lordship, they were asked to go out from the office, Lordship, then the door was locked from inside, and then, my lord, he was assaulted. It is the statement of the other witnesses. Lordship. But they have not mentioned, Lordship, who has implicated, my lord, who assaulted, Lordship, yes. That is not specific, but they have said that all the accused persons, they were present inside the office.
okay. Then I think their custodial detention is not necessary.
And that I leave it to your Lordship, my lord.
Third, Mr. A. Gautam, learned counsel for the applicant. Also heard Mr. R. J. Barua, learned additional public prosecutor, who has produced the case diary of Duliajan PS case number 27/2024, which was called for in connection with this case. Learned counsel for the petitioner has submitted that the petitioner Samiran Gogoi was allowed to go on interim bail by order dated 28/2/2024 by this court with certain conditions. And as per directions of this court, the petitioner has appeared before the investigating officer on 2 occasions, that is on 1st of March 2024 and thereafter 15th of March 2024, and has cooperated in the investigation. Stop. Learned counsel for the learned additional public prosecutor has submitted that though the petitioner has appeared before the investigating officer. They have denied he has denied his involvement in the alleged offense. However, other witnesses have deposed that the victim was detained and assaulted in the ASU office. Where? Dulyajan.
Duliajan Regional Office.
At Dulyajan. Stop. I have considered the submissions made by learned counsel for the petitioner as well as learned additional public prosecutor. And have perused the case diary of Dulyajan PS case number 27/2024. It appears from record that the petitioner has appeared before the investigating officer in pursuant to the directions of this court, and his statement was also recorded under section 161 of the Code of Criminal Procedure. As it appears that petitioner has complied with the directions of this court. This court is of this court, and has cooperated in the investigation, his custodial detention does not appear to be necessary if he continues to cooperate with the investigating officer. In view of above, the interim bail granted to the above named petitioner by order dated 28/2/2024 is hereby made absolute with conditions number within bracket Roman 1, 2, and 3 attached to the said order remaining intact. With above observation, this anticipatory bail application is hereby disposed of. In other cases, similar
22 to 34, yes.
on 2 occasions you have appeared.
Yes, yes.
In all other cases.
Yes, yes.
Same order except name of the petitioner will be different. In item number 32, 33, and 34, same order except the name of the petitioner.
Very, very grateful.
Incident. Yes.
May I please your lordship? 439 application notice. Petitioner was arrested on 2/2/2021. Today is about 3 years, 1 month. 1,154 days. And recovery is ganja from truck. That amount is 7.650 kgs.
No, just a minute.
Yes.
What was ganja? What was the weight?
Ganja weight about 117.650 kg.
117.
117.650 kg.
0.65 kg. Okay. From truck.
From a truck, an allegation is that we one of the petitioner was driving the truck and other was sitting inside the truck. Then lordship charge sheet submitted in this case. Then thereafter 11 numbers of witnesses cited in the charge sheet. Out of 11, thereafter lordship charged them on 3/12/2022.
Okay.
And after that lordship, out of 11 witnesses, only 4 witnesses examined till today. Lordship. Here, in this case, they have filed a objection, Lordship. Yes, as per my lord, their objection, what is written in the final complaint that is submitted, that was there. And one more thing I found in their objection, that on the basis of the statement of the 2 independent witnesses who were present at the time of interception, Rubul Varman and Sri Sujit Sarkar, who were not the independent local person of that locality, they made the statement that this vehicle was intercepted and mentioned the name. But after going through the statement of the independent witnesses as per from the record, I found that
Where is their objection?
objection they have filed. Lordship.
That is not been taken with the record laws.
Why?
Where is?
We file,
They file lordship. Only that?
they have to, probably.
Again.
Objection would be required.
Maybe taken up tomorrow.
Tomorrow some other more matters are there. We have to wait for whole the day. Lordship. He is there.
No, you are very elusive nowadays.
No, today lordship, there were
Oh,
60 matters were there in the different courts.
But this case,
But that objection would be required. Tomorrow at 2.
or something. Tomorrow because 3 matters, my 3 matters with him, Lordship. That is why Lordship may take up day after tomorrow or Thursday.
Then lordship on
Thursday,
4th of.
4th at 2, 4th at 2. Lordship.
Heard Miss S.K. Nargis, learned counsel for the petitioner. Also heard Mr. S.C.K.R. learned standing counsel NCB, who submits that the NCB has filed written objection against the prayer for bail by the petitioner. However, the said written objection is not available on record. The registry to place the said written objection with the records and list this matter again on 4th of April. 4th of April
at 2.
at 2 p.m.
Because he should be available on the Lordship.
To ensure at 2 p.m.
That,
Lordship, I comes to court at 10 o'clock and leaves at the court sizes. Lordship.
but in the NDPS cases, Lordship,
No, she was suggesting NCB should appoint more number of standing.
No, that
to
is,
assist him. Not to assist him, Lordship.
She is concerned about your
Yes.
load. Okay, at 2 p.m. day after tomorrow.
Not day after, no, on 4th.
On 4th.
on 4th.
Obliged to Lordship. Maybe that's 1 month after that, no? With pleasure, Lordship.
Yes, Mr. Mayor.
Lordship, 439 application and these 2 petitioners, they were arrested on 9/10/2022. But they were produced on 12/1/22, so they are in judicial custody since 12/1/22.
12?
12/1/2022. So now, today it has become 2 years and 1 month and 18 days since they are in custody. And in this case, they have cited 13 witnesses. And out of which, till filing only 2 were examined, and till today, 5 witnesses, out of which cross-examination of 1 witness is still reserved. So, my lord,
Our submission is that we are seeking bail on two grounds, my lord. Firstly, on the ground of delay in trial for both the petitioners, and the second one is on medical ground for petitioner number one, my lord. So regarding delay part, Your Honor, in this case, the cognizance was taken on 22/7/2022. This case was taken cognizance of by the court on 22/7/2022. And after that, my lord, for 3 dates, they have failed to file the copies to the accused. That is on 23/7/22, 5/8/22, and 16/8/2022. And out of these 3 days, on the last 2 dates, there was no representation by the NCB, my lord. And on the next date fixed, that is on 30/8/2022, the copies were furnished to the accused. And on 13/9/22, the charges was framed. And on 12/12/22, one witness was examined here. And after 3 months, then the case was fixed on 4/3/2023. It was fixed for evidence, but the evidence witness did not turn up. And again on 1/4/2023, it was fixed, but that was also declared holiday. So the case was next put up on 3/4/23. And it was again fixed on 10/5/23 for evidence. On that day also, the witness did not turn up. Now on 7/6/23, Your Honor, fairly submitting, on one occasion, there was a delay caused on the part of the defense, that is 7/6/2023. The counsel of the defense did not appear. And because of that, on the very next day.
You have prepared that list in this.
Yes, my lord, at para number 7, we have written in detail, my lord. Para number 5, my lord, sorry.
Okay.
Para number 5, 6. Para number 5 and 6, my lord. So this is the only date, my lord, where the counsel of the defense, he did not appear, and because of which the cross-examination was reserved. And except this date, in all other dates we are present, and because of the default on the part of the earlier counsel, a new set of counsel were engaged. And after that, again on 2/8/23, the witnesses did not turn up. 5/7/23, witness did not turn up. And 31/8/23, then the PO was transferred. And to speed up the trial, we even filed one transfer petition, which was registered as Miss Criminal 36/23, but that was dismissed, saying that already new judge has been appointed, so holding the petition to be infructuous, that was dismissed. Why we are submitting that? To speed up the trial, we have left no stone unturned, Your Honor. Even we have filed transfer petition in that case. Then again on 3/11/23, fresh summons were issued, and 1/12/23, evidence could not be taken. And now 1/2/23, evidence could not be taken, and 1/3/24. Then they have brought 3 witnesses which were examined, Your Honor. And now again, this case is next fixed on 24/4/24. That is in April 24th, the case was fixed. Now, my lord, out of these 13 witnesses, most of the witnesses, my lord, they belong to the NCB, they have transferred, they are now posted at various places. So it is very unlikely that the case may be culminated within at the earliest, my lord. So we have relied upon a judgment passed by your lordship only. So we have annexed it at page number 83, my lord. In that case, the delay was of 2 years and 5 months. And the bail was granted considering that delay, my lord. And in our case also, it is 2 years and almost 1 month, 18 days. And while passing that judgment, your lordship has discussed various rulings of Apex Court, various judgments, various orders where the Apex Court has granted bail, Your Honor, in cases where there was a delay of even 1 year, 6 months, Your Honor. 4 judgments, those were cited and discussed, Your Honor.
What ailment petitioner number 1 is suffering?
Petitioner, my lord, he was detected with tuberculosis, my lord, in the month of February 2022. Sorry, 23, Your Honor. 2 February 2023 at page 94, the relevant document is there, medical document. He was detected with TB and he was being treated by the jail authorities, but his health condition deteriorated day by day. And now his condition is such that he has been admitted in the hospital. Now he is in hospital, petitioner number 1. And a report was also called for on last occasion. And report has probably come and we have made a note from the record. Now in the report, Your Honor, in the investigation part, it was written like he was
Clinically diagnosed as TB.
yes, at investigation part at point number 2, Your Honor, he was diagnosed with this pulmonary Cox sequel. So we have consulted with some doctors that what does it mean? They said it is a severe, it is a problem related with severe breathing problem, Your Honor. He suffers from breathlessness and the medicines which are prescribed, that is number 2 and 3, presently medications. So these medications are also provided when he becomes, he finds it very hard to breathe, Your Honor. And sometimes he even vomits blood from his mouth. So this is his condition. So he's not getting proper treatment, Your Honor. His condition is very severe. So he needs to be treated in some better hospitals. And for that too, Your Honor, we are seeking.
What is his name?
His name is Hafizul Mandal. And my lord, these petitioners, they will appear, my lord, during the trial, they will face the trial. So during the course of trial, if they are convicted, they will face the consequence. But for the time being, my lord, they may kindly be released on bail.
Yes.
Let's come to page 45. Total recovery was 765 kgs of ganja.
765.
That's it. Now let's see page 67, paragraph 46.
It is page 45.
Is the page 45.
Page 45 is your complaint.
File and complaint.
Okay, okay,
Recovery and seizure of 765 kgs of ganja.
okay.
Now let's see may come to page 67. With the role of the both the accused has been summarized here.
Page 67.
67, paragraph 46. Paragraph 46 and 47. 46 with respect to accused number 1, Hafizul Mandal petitioner, then accused Abdul Khalik. Facts mentioned in the seizure memo, Panchanama of the instant
This
case.
is part of the complaint petition.
Yes, Lord.
Okay. These are the allegations.
Because from conscious position, both the petitioners, ganja was seized.
What it says, paragraph 46.
46, 1. Facts mentioned in the seizure memo Panchanama of the instant case, according to his in the instant case was recovered from the his conscious position. Telephonic communication between Hafizul Mandal and supplier Debu, partner during so and so. Location of the accused at interstate truck terminal, Madhabbari, Jirania, West Bengal, on the date when he took the ganja loaded truck number so and so, and thereafter his movement towards Assam. Then paragraph 47 is with respect to accused number petitioner number 2. Facts mentioned in the seizure memo Panchanama of the instant case, according to which the ganja seized in his case was recovered from his conscious position. But the contraband seized from both the conscious position of both the accused persons. Now, Lordship, with regard to submission of my learned friend, there is a delay in the trial. Lordship has noted the dates. I cannot dispute it is, but for quite some time there was no court. All the application was filed. And out of 8 total 15 witnesses, 5 has been examined. Last week witness was examined on 2/3/2024. Lordship pleased to see.
Last witness was examined
on 2nd of March 2024.
Total 5 witnesses are.
Yes, and Lordship, another submission. Lordship pleased to peruse the record. The dates were given with the interval of 2 months, 3 months.
By the court.
Yes, Lordship. Lordship, recently, I'm relying on 3 judgments. 2 passed by the Honorable Supreme Court. Lordship, in Gurvinder Singh versus State of Punjab, in paragraph 32, the Honorable Supreme Court says that in case of heinous crime, delay what is the paragraph 32. Although this case is related to UPA Act, Lordship. So I am placing 3 last lines of paragraph 32. Page 10. Last 3 lines. Therefore, mere delay in trial pertaining to grave offences as one involved in the instant case cannot be used as a ground to grant bail. Hence, the aforesaid ground on the behalf of the appellant cannot be accepted.
Which line?
Last 3 lines of paragraph 32. Lords. Therefore, mere delay in trial pertaining to grave offence as one involved in the instant case cannot be used as ground to grant bail. Hence, the aforesaid argument on behalf of the appellant cannot be accepted.
Okay.
Lordship, another judgment, the State of Inspector of Police versus B. Ramu. This is announced on 2nd of February, 12th of February 24. Paragraph 7, 8, 9, and 10. Although the matter was relating to granting anticipatory bail by the Madras High Court, but the Honorable Supreme Court analyzed all the aspects of the NDPS Act, and in paragraph 11, I'm placing paragraphs 8, 9, 10, and 11.
Yes.
I'm harping on paragraph 11 mainly, Lordship. In case of recovery of such huge quantity of narcotic substance, the court should be slow in granting even regular bail to the accused. What to talk of anticipatory bail, more so when there is accused is alleged to be in a previous criminal intimidation. So here it is Lordship law laid down by the Honorable Supreme Court that in case of where commercial quantity of narcotic drug or substance, that in case of recovery of such huge quantity of narcotic substance, the court should be slow in granting even regular bail to the accused, but not to talk about anticipatory bail.
Slow means how much slow?
Lordship, because embargo of 37 will be there.
No, you have.
That's depend upon the Lordship facts and circumstances of the case.
Because their case is that prolonged incarceration.
Lordship, in my humble submission, that will not come in the case of this type of nature of case, where huge quantity has been recovered, and where from the conscious position of the petitioner. Lordship has seen when the Supreme Court is granted bail, either they were found accompanying the truck and the possession, nothing was recovered from their possession. But here in this case, the contravention is from conscious possession of both the accused persons. Let's say with regard to different judgments of Honorable Supreme Court, this Honorable Court on 13 to 24 discuss all the
No, where, how you are, why you are saying that conscious possession?
because Lordship paragraph 46 and 47. And in page 45 also, we have in the course title, let's me please to see page 45. Recovery of seized 765.380 kgs of ganja from Ashok Leland container truck bearing registration number so and so from conscious.
Where are you reading?
Paragraph 45. Top clause.
Yes.
Recovery and seizure of 760.380.
Paragraph 45 at page?
No, this is a page 45 plot. Page
No.
45 is a opening page of complaint plot.
Okay,
Post title,
yes.
top plots. Recovery and seizure. What you got?
Yes.
Of 760 kg of ganja from the Ashok Leland container truck bearing license number so and so from the conscious possession of accused Hafizul Mandal and accused Abdul Khalik on 9/1/2022 near Health City Hospital. And summary is there in, at page 67, paragraph 46 and 47. Look. And let's see further my submission in Until's case, Honorable Supreme Court says that section 436 capital A will be applicable in case of NDPS also. If he applies that provision, Lordship, even then Lordship, the minimum punishment, maximum punishment is 20 years. Lordship. We applies that law also, then Lordship, we cannot say there is a delay in trial. Lordship. What's the point placing on the
No, this you have to explain.
What's it?
This Antil's case.
What's it?
Where it says that 436A is applicable
In
in
case of
NDPS case.
Lots.
Does it mean that we have to wait till that period?
No, Lordship, my humble submission, if he applies this law, then the only 2 or 3 years has been passed only.
No, that I want to understand. Whether that observation means that before the period, half the period of the sentence is over.
Lordship.
In a case involving commercial quantity of contraband, the accused cannot be allowed on bail.
Then Lordship, embargo of 37 will come, then Lordship has to come to a finding.
Then how would you read the judgment which has been cited by the counsel for the petitioner, where it says that prolonged
Yes,
incarceration?
Lordship, that's why I'm placing on judgment of this honorable court, although it may not be binding on your Lordship, but for perusal of this honorable court, occasion to consider all the judgments which have been placed, that has been discussed. And in paragraph 4, and page 3, all these judgment has been considered by this honorable court.
Okay. What was the finding?
Finding Lordship, paragraph 12, 13. Ultimately, bail was cancelled, Lordship.
No, but that for prolonged incarceration, bail cannot be granted. Is there any such finding?
Lordship, paragraph 19, 20. In view of the above, In view of the above, paragraph 19, I'm reading, Lordship. In view of the above, and also in view of the embargo of section 37 of the NDPS Act, this court is of the view that it is a not fit case where the privilege when we
In that specific case,
it is well settled the Honorable Supreme Court in case of
that is the observation with regard to this case before the court.
here,
But
Lordship, here also, the accused was arrested on 3/2/2021
no,
in this case.
why I am putting queries because when Supreme Court has itself stated in some of its judgments that for prolonged incarceration, even 37 embargo is not applicable.
Lordship is to see whether any law has been laid down. But only in Ravi Prakash, Lordship, the facts of the case is that the petitioner was traveling in the truck. Nothing was recovered from him. And in case of Lordship, the Muhammad Muslim, the facts of the case are also different, Lordship. And Lordship is to see all these orders placed before this Honorable Court or different courts passed by the Honorable Supreme Court. They were not, in my humble submission, no law has been laid down. All these cases were decided on the facts of the present, that case only. Nothing, no law has been laid down. Whereas in case of Mohit Agarwal and other judgments, Lordship, Honorable Supreme Court is obliged to consider all aspects of the matter, Lordship. And the judgment which I placed, Lordship, in that case also law has been laid down.
Which judgment?
Lordship,
Ramu.
Ramu case, B. Ramu. And
But
Gurvind.
now Ramu is with regard to a anticipatory bail
Yes, Lordship. That was-
where a observation has been made by Supreme Court.
Lordship, may please to see paragraph 11.
No,
And place
there
it.
is, you are saying that Supreme Court has laid down law.
Lordship, in my humble submission, this is a ratio because in paragraph 11, I am again reading it. This is a humble, Lordship may consider whether.
No, we are concerned with the bail application under section 439.
Lordship. But here, Lordship.
In a case where Supreme Court makes an in a case under section 438, Supreme Court makes an observation that even in regular bail,
The court should be slow.
court should be slow.
in grant.
You are saying that now law has been laid down.
Lordship, in my humble submission, this can be a.
But you are saying that in Ravi Prakash law has, where Supreme Court says that
Lordship, in that case, in my humble submission, because the facts of the case are quite different.
in this case, how facts are similar?
Lordship.
In this case, facts relates to the anticipatory bail only.
Here, because Lordship, in my humble submission, in paragraph 1, that is a ratio of this case. Because Lordship, it is a very clear, the Lordship.
No,
please-
paragraph 11 ratio only with regard to the anticipatory bail, not with regard to a regular bail application.
Should be slow in
Because
granting.
regular bail application was not before the Supreme Court.
No, no, that's why my humble submission, my submission was that this case is related to anticipatory bail, not a regular bail. But in paragraph 11, it has been clarified. Then I'll Lordship, what is the ratio and what is the ratio decision? I may allow, I'll place all the judgments before consideration of the Lordship. Whether this paragraph can be considered as a ratio or not.
No, you have to make me clear in view of the judgment of,
Ravi
because
Prakash.
in several cases,
Yes, Lordship.
we are confronting with
Yes,
same
Lordship.
issue. Where this court has held that where there is prolonged incarceration, and if court comes to a
Pending.
court comes to a conclusion that in a particular case, there has been prolonged incarceration,
Yes, Lordship. That is Lordship has to
Then-
see from the records, lower court.
then the embargo of section 37 is not applicable as held by apex court. You are saying that that is not the law laid down by,
No, no, Lordship, it is no. Section 37, if there is a long incursion, then 37 will not become. I cannot submit beyond the law laid down by the Supreme Court. My humble submission in case of Ravi Prakash, Lordship, the facts of the case was that the petitioner whom the bail was granted.
no, facts may not be similar.
No, no, Lordship, because Lordship, we have to apply all these things because this is how we can interpret all these judgments. And if in my humble submission in the case of Ramu, my Himal submission, Lordship. Paragraph 11 is the law.
Paragraph
11, which I, Lordship, is want to clarify. In case of recovery of such a huge quantity of narcotic substance, the court should be slow in granting even regular bail to the accused persons. Then what to talk of anticipatory bail?
your submission is that this is law
In
under
what- thi- thi-
141
thi-
or
This is a ratio laid down by the Honorable Supreme Court.
ratio for deciding that case,
Yes,
which
sir.
was before the Supreme Court.
Because this will be applicable in all the cases, Lord. This is my humble submission. Lordship, recently in the case of that SS surfacing was revisited by the Honorable Supreme Court. In
Which
that
case?
That Allahabad High Court Bar Association, that in case of SCS surfacing, that 6 months stay order that was vacated. In that case, there is a observation. Today I have not brought that judgment. Lordship may take up tomorrow. I'll place all these judgment for consideration. of Lordship.
Okay. We'll take it up tomorrow.
Because
Just
Lordship,
to-
Because similar cases,
Yes, my lord, he is in.
there are many NCB matters where the trial is going on for 2 or 3 years.
that is fact,
And
Lordship.
the,
Because Lordship, another court has taken cognizance.
because
Why court is not fixing the cases in the regular basis? Because in some cases like this, 3 months, 4 months time has been granted.
we have to decide who
Yes.
will get the benefit, whether accused will get the benefit, even if,
Now, Lordship, under section 309, it is the duty of the trial court to fix the case on.
suppose trial court's faults in applying 309,
Then Lordship.
who will get the benefit?
No, Lordship, obviously, nobody will get benefit in my humble submission.
Then you will continue to incarcerate.
Law has to be let down by this honorable court, Lordship, directing the trial courts.
Okay, we'll continue our hearing.
And Lordship, in case of that case also, so Supreme Court has considered regarding delay all this cases.
Which case?
That Allahabad High Court judgment. That SRE servicing was revisited by the Honorable Supreme Court. Supreme Court says that stay will be, automatically there will be, stay will not be vacated. And considering this in paragraph probably 17 or 18, Supreme Court has also gave a direction to the courts.
No,
with
I'm
respect to that.
putting a query again before we wind up. He has relied upon a judgment of this court
Lots.
by me, where I have understood the law cited by Supreme Court in a particular way.
Lots.
You have to place on record the materials to convince me that my my understanding was wrong, and therefore it needs to be relooked into. Otherwise,
Lordship, in my submission, in case of bail, previous judgment passed by Lordship or some other courts, that are not binding on your.
no. In every case, facts would matter.
Yes, Lord.
But basic principle that
Yes,
that whether in a NDPS case involving commercial quantity of contraband, if there is a prolonged incarceration, whether accused will get benefit. If so, if he gets, if yes or no, if no, the question stops. If yes, what would be the
Criteria.
delay when he will get that?
then Lordship has to see what is the meaning of long incarceration in case of.
Yes,
NDPS.
that you have to make submission. Because the cases cited by the petitioner shows that Supreme Court, though have not dealt with this issue in a very detailed manner, but have given benefit to accused persons who are behind the bar for 1 year, 6 months on the ground of prolonged incarceration.
There are so many cases where Lordship trial is not completed with even 3 or 4 years. This honorable court also rejected the bail in many cases.
Yes, there are.
I'll place all the judgment.
There are conflicting.
We cannot say this is a conflicting.
It depends on the facts to
Yes,
fact.
depends on the.
Okay. Tomorrow
Okay.
we'll continue.
It's not, we will be furnished the copies of the judgments.
He will give you citation.
Yes, that will be.
Heard Mr. D. Gopal, D. Medhi,
From
Learned-
DK meeting.
D.K. Medhi, learned counsel for the petitioner, Also, Mr. A.C. Kayal, learned additional public learned standing counsel NCB. The hearing remains inconclusive. List this matter again on. You take a date which
Then
is
fourth-
convenient to you.
On fourth, Lordship.
Fourth, we have already for similar matters.
Lordship,
You
because
can-
it will require for all the cases, Lordship. Once your Lordship has decided that will be applicable to all the cases.
On fourth, Mr. Mehdi. On fourth.
Mention item number 42. It has been coming up as a delay condonation petition, item number 42. Can it be taken up day after tomorrow or on 4th?
Okay. Delay condonation.
Delay condonation, item 42
Item 42 on fourth.
on 4th.
Fourth.
Obliged.
Other matters, if it is not urgent,
Delay condonation of 17 days, my lord. So it makes
Delay,
item 41.
delay
delay
condonation.
convention of 56 days.
When do you want?
Lordship on any early date, your lordship. Can it be on 4th? your lordship?
Fourth.
Much obliged.
Okay, item number 44, Lordship, it is wrongly listed in order column. So it should have been come for admission, Lordship. Appeal against conviction, Lordship.
Item number 44. About Mr. A. Ahmed, who submits that this matter has been wrongly listed in order columns. It should have been shown in admission column. Let this matter be listed in admission column on,
Friday, Lordship. Only it will be admitted and record will be followed.
okay, on 5th of.
Obliged.
Lordship, item 43. Lordship, this is an IA under section 389. The matter has been coming up. Lordship, may take it up on 3rd or 4th, any convenient date, Lordship.
Fourth,
Lordship.
item
Thank you.
43 fourth.
May I please, Lordship? Item number 17, matter, the matter of NCB matter.
It will be on day after tomorrow, along with the other matters. You are also on prolonged incarceration.
Yes, ma'am. The matter, that matter may be listed on 4th matter, already similar matter on the 4th.
Fourth.
Not
Obliged.
obliged.